Wait a couple of minutes past the hour since a bunch of people will be joining, I guess. Also, it's dark metal. All right. Good morning, everybody, or good afternoon, depending on where you are. So we are about to start day 2 of the Machine Learning and Economic Inequality Conference. And today's start will be focusing on a number of talks from a legal perspective. And I'm very happy that our first speaker today is going to be Pauline Kim, who will talk about bias in ML models, legal challenges. And Pauline, the floor is yours.
Great, thank you. Thank you so much for including me in the conference. I really enjoyed the papers that I was able to see yesterday, and I just regret that I had to leave early, and unfortunately I'm going to have to leave early again today because I still have teaching responsibilities. But my talk today, I'm going to focus on inequality that is faced by historically disadvantaged groups. This is not identical to the issue of economic inequality, but it is an important aspect of it because resources and opportunities are distributed in ways that systematically disadvantage certain groups. And so in my talk, I will be focusing primarily on race and to a lesser extent on gender bias and discrimination, partly for ease of discussion, but also because those are characteristics where I think there's some broad consensus that discriminatory treatment both occurs on a widespread basis and is also unfair. So there are a number of well-documented instances of bias in machine learning. We have seen this with the study done on the recidivism prediction software used in the US, facial recognition software, predictive policing models. All of these have been documented to involve and to raise risks of bias against groups that are historically disadvantaged. My particular focus is on the employment relationship, and so I'll be talking about instances and risks of bias and discrimination when machine learning models are used to make employment decisions. And in particular, my focus will be on the challenges that these technologies pose for the law. Now, I have a colleague who says that if you have a hammer, everything looks like a nail. And I am a lawyer and a legal scholar, and so I naturally go around looking for legal problems. But even though my talk will be sort of more focused on the legal aspects, I don't mean to suggest that these are only or exclusively legal problems or that law is necessarily the tool best suited to address them. But it's the tool that I'm the most familiar with. And when it comes to dealing with questions of discrimination and bias, there are at least a handful of legal tools that we can begin to kind of examine and try to leverage. So in my talk, I'm going to discuss briefly a couple of earlier papers I worked on looking at risks of bias in the hiring process and in recruitment. And then I'd like to talk about, in the second half, some current work I'm doing on efforts to build fair models. So in each of these cases, I will again be touching on legal challenges that are posed and try to explore some of the legal ramifications. So in the hiring context, employers have increasingly come to rely on predictive AI tools to sort, screen, and select among job applicants. And in earlier work, I have explored the ways in which these technologies are being used and the risks of bias that they pose. One of the promises of machine learning was that it could help us to avoid human bias, because people have been making hiring decisions for a long time, and their innate, whether conscious or unconscious biases have historically worked against certain disadvantaged groups. And these phenomena are well established by social science studies. So there's the famous study, the field study, where the researchers sent out paired resumes and just changed the name on the resume. One of them had a white sounding name, the other had an African American sounding name, and they found that the responses were quite different, that the resume with the white sounding name got far more callback interviews, even though the underlying qualifications of the person were exactly the same. And so the promise of turning to predictive models was that we could avoid this kind of human bias. But the problem is those biases can persist and they can be reproduced in models. And so again, this is a well-known example of Amazon trying to create a AI tool that would identify promising candidates for software developer position. Amazon is growing, still is growing rapidly. The way they tried to train the tool is by asking it to find prospective employees that were similar to their current employees. But because their current software developers were overwhelmingly male, the tool learned to select primarily for male software developers and to downgrade women even when they had similar skills. These are anecdotal examples. There are a number of different reasons why we can expect that there is some risk of bias appearing in these kinds of models. And this is, I won't go through this, I think this is all well explored in the literature. But in the employment context, there are some particular concerns that relate to the legal regulation. One is that these models often rely on purely correlational factors rather than causation. The visual image here is one of my favorite one of my favorite correlational stories, which is the study that found that people who like curly fries on Facebook are more intelligent. There's strong correlation there, apparently. Clearly not a causal relationship. How do we think about that in the employment context where you have characteristics, features that are clearly non-causal but are being used in a predictive way? Another concern is opacity. There is often a lack of information or understanding about exactly what factors are driving predictions, and those raise particular concerns in the employment context. Once a predictive model is deployed in the employment context, the problem is we are no longer going to observe the counterfactual. If an employer is relying on the predictions to make hiring decisions, it may be that there appears to be some level of accuracy in the predictions, but we don't actually know about false negatives anymore. And then finally, the use of these tools is embedded in a larger system. And one of the things we have to worry about is feedback effects on the labor market more generally. And in particular, if there are forms of systemic bias that can lead to discouraged workers who can actually change worker behavior. Just to run through the basics of employment discrimination law, it recognizes two forms of discrimination. In the US, we call these disparate treatment and disparate impact. I think they're called direct and indirect discrimination in other countries. But basically, disparate treatment forbids an employer from taking an adverse action because of the protected characteristics, whereas disparate impact prohibits engaging in neutral practices that have disproportionate effects on a protected group. Now, one of the things that I think sometimes gets obscured is the mere existence of a disparate impact does not give rise to legal liability. It just triggers further inquiry. And the employer always has the possibility of coming back and arguing that the practice, which has a disparate impact, is one that is in fact related to the job and there's some kind of business necessity for engaging in it. Many disparate impact cases actually get resolved at this stage in favor of the employer if they are able to show this kind of job relatedness. So given the risks of bias in machine learning models when they are used in the hiring context, this poses a number of challenges for anti-discrimination law. First of all, disparate treatment isn't much help here because if we simply remove variables for the sensitive characteristics, that's not necessarily going to stop the predictive models from having a discriminatory effect. But once we move into the disparate impact side of the theory, it's difficult for the law to deal with things like unexplained correlations, opaque decision processes, because these don't offer any clearly articulated justification for the reason that the impact is occurring. And so for that reason, it's a little bit difficult or uncertain to know how existing anti-discrimination law would apply to a model that has a disparate impact, but we don't really understand the underlying reasons. So what I have suggested is that we may need to tweak our understanding of anti-discrimination law rather than just taking sort of the employer should know nothing about sensitive characteristics. It may sometimes be important in situations where predictive models are being used to preserve sensitive data so that the outcomes can be audited. The employer, I think, should have to show something more than simply a statistical correlation. Instead, they should bear a burden of showing that the relationships that they are relying on are statistically valid and substantively meaningful in some way. I'm going to skip that in this part in the interest of time and move on to talk about recruitment. So this is another area that I have looked at. If we move the employment process back in time a bit, before the employer is at the point where they're deciding whether or not to screen somebody or hire somebody, prior to that moment, we now have a number of labor market intermediaries who are channeling information between potential job seekers and the employer. So these include online advertising platforms like Facebook and Google. Most employers now look for employees by posting ads on these types of platforms. There are also platforms like ZipRecruiter that are specifically dedicated to matching applicants and employers. And then there are platforms that are promising to help employers find the passive candidate, someone who's not actually actively looking for a job, but would be a great match and could perhaps be recruited away. So the concern with these intermediaries is that they are controlling and shaping the flow of information in labor markets in ways that I think has been underappreciated and certainly was not taken into account when existing anti-discrimination law was put into place. I think one of the well-known examples of this is the Facebook advertising platform. A few years ago, Facebook got quite a lot of negative press because it was pointed out that when an advertiser, including somebody who was posting a job, was choosing how the ad should be distributed, they had the opportunity to use things like age and gender, which could be used to discriminate, and location, which is often a proxy for race. So the concern was that employers with nefarious motives could use these selection tools to try to target their ads for job opportunities to particular audiences. And Facebook was sued over these practices, and they eventually settled. And the terms of the settlement required that Facebook create a separate portal for housing, employment, and credit advertisements, the kinds of things that are sensitive and that we worry about discriminatory bias. And in this portal, if you were going to post one of these ads, you had to go to this portal. No demographic targeting was permitted, no direct use of, no use of attributes that could help you discriminate. and no location-based targeting less than a 15-mile radius. And the idea was, by removing these options from the advertiser, the targeted audience would be balanced. But the problem was that even once this target audience was selected by the advertiser, Facebook's ad targeting algorithm would then step in and decide which users actually received the ad. So the algorithm is predicting which users are most likely to interact with the ad, likely doing so based on either past behavior or inferences that are being drawn about users based on people who are like them. And so the risk is that this ad targeting algorithm would produce skewed delivery of these employment ads, even if the initial targeting criteria were neutral. And in fact, there were a couple studies that showed that this does in fact happen. This was a study in which the researchers posted a number of job ads, used neutral language in the ad and in the targeting criteria. And as you can see, the ads were distributed in a race and gender skewed way, in a way that reflects stereotypes about who would do what kinds of jobs. There was another study after the special portal was implemented, and this is just one example from that study. This is a construction company that was looking for drivers. They targeted the ad in a neutral way, and when they looked at the analytics afterwards, the tall blue bars are men and the shorter green bars are women. You can see that the ad was overwhelmingly served to men rather than women. And the company said that's actually not what we intended at all. We're happy to have men or women. We need drivers. So the concern here is that the algorithm, the ad targeting algorithm, was introducing a bias that was not intended by the employers who were posting these ads. In addition to the advertising context, we also have platforms like ZipRecruiter that are acting as intermediaries in the job market. And ZipRecruiter, one of the ways that it works is if an employer posts a job, it scans the tens of thousands of resumes that it has, job seekers have posted, and looks to find the best matches, nudges some individuals to apply for the job. When they do so, that produces a ranked list of recommendations to the employer, and the employer has the opportunity to look at those and to give a thumbs up to some of them, saying that this is the kind of person we're looking for. We think this is a great match, and that signal is then used to identify similar candidates. So again, there's a concern that the underlying recommender systems that are driving platforms like ZipRecruiter can reproduce bias. And to be clear, I have no knowledge of any problems with ZipRecruiter's system, but I think there are reasons to worry about platforms like this. One of the problems with these job matching platforms is they are not generally able to observe the skills and abilities of workers directly, which means that they are probably primarily resting their predictions on observed market behavior. In other words, who is likely to be hired by this employer rather than who has the skills to perform this job. And to the extent that those prior behaviors might reflect biased judgments or forms of historical workplace bias, there's a risk that they will be reproduced by these predictive models. So again, the rising importance of these labor market intermediaries raises some challenges for employment discrimination law. One of the challenges is thinking about this question of who is an applicant. It used to be pretty easy to figure out if somebody could bring a claim alleging that they had been discriminated against, or to determine if there was a disparate impact by a given practice by examining the applicant pool and the outcome of that practice. But now the question of who is an applicant is a little bit more complicated when you have intermediaries who are screening and channeling and promoting certain individuals to apply and perhaps not being transparent about those opportunities to others. Another challenge is figuring out who is responsible if these kinds of biases are happening in the recruitment process. The law tends to be very employer focused, so it is really, the law traditionally has located concerns about discrimination with the employer's decision-making process and has paid less attention to how employees get to the employer. There are provisions for covering employment agencies, but they're not well developed, and there's this sort of uncertainty about whether platforms that are acting in this way of channeling certain types of information about job opportunities should or can be treated as employment agencies. And then in the US, we have our own peculiar challenge if platforms were to be held responsible, which is our Section 230 issue of platform immunity, but I won't go into that here. So, this prior work has led to some new questions. We know that algorithms can be unfairly biased against historically disadvantaged groups. And as a result, I think there's a lot of activity now in the computer science community trying to address bias and try to figure out ways to build fair models. But doing so requires an awareness of race or other protected characteristics in the model building process. And so that raises a further legal question. Is the consideration of race or other protected characteristics in the effort to mitigate bias itself a form of unlawful discrimination? And so this is work that I'm working on currently, exploring this from a legal perspective, and then, as I'll mention in a bit, some experimental work with folks here on campus at WashU. So before I go into the details of this, I just want a couple of caveats. I am not trying to address the ongoing debate about how fairness should be defined. I'm not endorsing any particular model or strategy for mitigating bias in predictive algorithms. I have concerns about some of them, even apart from their potential issues about legal liability. I think those are all really important questions, but I'm not dealing with them here. Instead, my purpose here is really just to try to think through, are there any legal obstacles to undertaking these kinds of efforts? So to go back to the model of anti-discrimination law, we have two theories of discrimination: disparate treatment and disparate impact. And so now I want to delve a little deeper into the disparate treatment side of things. Disparate treatment law clearly forbids explicitly discriminatory policies. That's easy. And it also forbids actions that are taken with an invidious intent or motivation. For example, the employer who doesn't hire somebody or fails to promote them because they hold some kind of animus or prejudice against that person because of their race or their sex, that would be a form of discrimination. But what about affirmative action? There have been a number of challenges in the US, legal challenges brought by white plaintiffs or by men who have argued that taking race or sex into account in any way that benefits disadvantaged minorities or women is itself a form of race or gender discrimination, and therefore should be unlawful under existing discrimination law. And so in a series of cases, the US Supreme Court has addressed these issues. Many of these are not in the employment context, so here I'm speaking about the legal framework somewhat more broadly. And so in this series of cases, the Supreme Court has articulated distilled a couple of principles. First of all, the Supreme Court has held that using racial classifications, even for a benign purpose, like affirmative action, is still, in its view, a form of discrimination, and therefore it is unlawful unless it can be justified. And in order to be justified, it has to meet the standard of strict scrutiny that the court has laid out. Strict scrutiny would require that the entity that is using the racial classification show that it is doing so for a compelling interest and that the means it has chosen to do so are narrowly tailored to meet that interest. So if we return to this summary of anti-discrimination law, we can say that there are at least three different ways that disparate treatment occurs. And one of them is if an employer or other entity engages in affirmative action, unless that affirmative action plan can be justified. Now, I just want to, an aside here, the jurisprudence that has been developed by the Supreme Court has been subject to significant critique. Critical race scholars in particular have argued that the court's doctrine, first of all, does not actually reflect constitutional principles, and it ignores the way in which neutral practices can systematically harm racially disadvantaged groups. But my purpose here is not to engage in that normative debate over whether what the Supreme Court has decided is correct or not. Instead, what I want to do is just accept those cases and that law that it has established at face value and examine that reasoning and ask, how does this law apply to race-aware efforts to mitigate bias in protective models? So to return to this core question, is consideration of race or other forms of protected characteristics to mitigate bias, is it a form of unlawful discrimination? Now, there are a handful of scholars in the US who have started to address this question, and several of them have come to the conclusion that the answer should be yes. It is a form of unlawful discrimination, but, or I should say, they have concluded it's a form of disparate treatment, but it can be justified under existing affirmative action law, at least in some circumstances. And they have worked through arguments about compelling interest and narrow tailoring and so on. But I actually think that this is the wrong approach. I think there's a prior question, which is race consciousness in the model building process disparate treatment at all? In other words, before we get to the question of whether it can be justified as a form of affirmative action, we should first ask the question, is the use of race in the model building process, does it constitute discrimination at all? So, and I think the answer to this is somewhat more complicated than the initial answer given by these other scholars. So it is certainly true that the court has found that some forms of race conscious practices are disparate treatment. And generally speaking, if you look at those cases, they involve racial classifications. In the typical case, you have a government or a private entity that is applying a racial classification to individuals at the time of decision to determine whether or not that individual will receive a resource or a benefit. So for example, some of the cases that came in front of the Supreme Court involved, one of them involved a medical school that set aside a certain fixed percentage of seats in the incoming class for minorities. Another involved university admissions where, based on race, certain applicants could get an automatic boost of a certain fixed number of points for their application. Others have involved government contracting programs where a certain fixed percentage are set aside for minority-owned companies that wanted to obtain these contracts. So in these kinds of situations, the court has said the use of racial classifications triggers strict scrutiny. In other words, it's unlawful unless the demanding standards of strict scrutiny can be satisfied. But race consciousness is not the same thing as racial classifications. And the law has also recognized a number of race conscious practices that don't constitute disparate treatment. And so they don't trigger this strict scrutiny at all. They're considered lawful. So for example, employers are permitted to pursue a goal of increasing the diversity of their workforce. In doing so, they may do things like change their recruitment practices in order to attract a more diverse applicant pool. They may change their testing procedures if they find out that a test that they're using is having an unintended and unjustified disparate impact on minority workers. In trying to develop a new test, they may do something like deliberately oversample minority workers in developing the test in order to ensure that it is fair to all groups. The Supreme Court has also suggested, now this is more in dicta than in cases that have actually been decided, but the Supreme Court has suggested that government entities can do things like engage in targeted outreach to minority communities, or taking into account the racial impacts of different policies in deciding questions like, for example, where to locate a new school. Government is also permitted to seek to remove barriers that have prevented minority-owned businesses from competing successfully for government contracts. These practices are all race conscious, and they all appear to be lawful, which means that they require no special justification before a court. So to go back to my original question, is race consciousness in the model building process disparate treatment at all? I think it's important to recognize that anti-discrimination law does permit some forms of race conscious actions intended to remove arbitrary and unfair effects that disadvantage certain groups. Whether a particular use of race in this process is disparate treatment will depend on how it is used. And this is where, these are sort of tentative thoughts where I'm sort of trying to work out the implications of this, but certainly I think there's a pretty clear case that efforts to debias models by dealing with data problems, thinking about things like whether we have representative data, how it's being labeled, whether there are biases built into the data and trying to remove it. Those to me should all be entirely legally permissible. They shouldn't be considered a form of disparate treatment that somehow triggers this kind of special scrutiny. Another category of strategies involves using protected characteristics at training time, but not at prediction time. So the training process then makes use of the protected characteristics to try to build a model in a way that would minimize the bias, but then at the time of prediction, the individual whose outcome is being predicted, for that individual, there's no access to race information, and so it's not part of the prediction process. And I think that arguably those kinds of strategies are not disparate treatment either, although with a caveat that if somebody were doing this sort of intentionally trying to design a facially neutral model with invidious intent, that could cross the line to disparate treatment and should be subject to scrutiny. But the most difficult question, I think, is what about models that take advantage of or use the protected characteristic of race at prediction time? Or how would those be treated under the law? And using race at prediction time may sound like a racial classification, and depending on how it's used, it may be considered a form of disparate treatment and therefore subject to strict scrutiny. But I think it's not universally true. I think it may depend on the ways in which race is used and the actual impact that it has. So this leads into another project that I've been working on, and this is with folks in the computer science department here at Washington University. One of the arguments that has driven challenges to affirmative action is the assumption that by taking race into account in a way that is intended to be fair for previously disadvantaged groups, that other individuals who are not part of those groups are somehow being harmed by that. And so this raises the question when we're dealing with race-aware models, what is the impact on individuals in the population from these race-conscious efforts to impose some kind of fairness outcomes? So the argument here is that in order to evaluate whether an individual has suffered from disparate treatment, we need to know what kind of an impact the fairness strategy is having on the particular individual. And so that's this current project looking at the individual impact of group fairness. And in this project, we are trying to ask this question: how does the move to group fairness learning models impact individuals as compared with the outcome under conventional learning? So a naive view might say, well, and this is I think it sort of parallels arguments that have made by some challengers of affirmative action programs. A naive view might say, well, if I'm not part of the group that is intended to be benefited by this program, and I don't receive a positive outcome, then I must have suffered from a discriminatory action. You took race into account, I didn't get the resource or the benefit, and so I have been discriminated against. But that can't be true of everyone in a situation that involves scarce resources. Not everyone who applies will get hired. Not everyone who applies will be admitted to university, regardless of race. So we would want to see whether that person would have gotten a positive outcome in the baseline situation, in this case under a conventional learning model, to see if their situation changed once a fairness model was adopted. So if someone would have received the resource or opportunity in the conventional model, but not under the fairness constrained model, then you might argue they have been impacted by the adoption of the FAIR model. And so we call this observed impact. But this is not quite right either, because there is not a single objective authoritative solution in the baseline condition. And so we can't say with any certainty whether a particular individual would or would not have gotten the resource. Instead, it's more accurate to say that there are a multitude of possible models that could have been used in the baseline condition. And this set of models includes a number of variations that will occur not only from the choice of the mathematical model, but what data set is chosen, which subset is used for training, what features are included, how the data is labeled, and so on. Now, the same would be true about the fairness model. There's a set of models that are chosen there, but for the moment, we'll ignore that. But just focusing on the variation in the baseline condition, we think it's more accurate to characterize the individual as having had some probability of a positive outcome in the baseline condition, which can then be compared with their outcome under the group fairness model. So understanding the impact of adopting fairness strategies is more nuanced than simply saying that someone who's not a member of a minority group is automatically harmed when group fairness considerations are built into a model. So we are trying to explore this question experimentally. We are assuming a situation in which there's a machine learning model that is used to make predictions, and it will be used to allocate resources. The resource is a scarce resource, so not everybody will get it. When we look at the baseline condition, understanding that there are a number of different conventional machine learning models that could be used, we still simplify by choosing a particular conventional machine learning model. And then what we do is we see what random variation in the data, what effect that will have, because the idea is that just the random variation in the data in and of itself, even with a fixed conventional model, is going to produce some natural variation in outcome in terms of whether a particular individual is allocated a resource. And so what we are doing is we have on several different data sets we're working with, but for each of them, we draw 50 random subsamples. We use each of those subsamples to train a model, and then we observe the probability that a particular individual is given the resource across these 50 models. And we call that the natural variation in outcome. That's the variation that occurs just as a result of the random draws of the data to train the model. That natural variation can produce what we call phantom effects. In other words, if you looked only at the observed impact, which I outlined on an earlier slide, and you don't take into account the natural variation, the impact on a given individual may look much larger than it actually is. And then we argue that the actual impact is more accurately measured by marginal impact, the observed impact less the natural variation that occurs in the baseline condition. So we have some our preliminary findings, although we're still working through this. First, there's a meaningful amount of natural variation that occurs in terms of whether a given individual will receive a resource, and that results simply from the random draws of the training data. The observed impact is often larger, sometimes much larger than the marginal impact. In other words, that because there's a meaningful amount of natural variation, there's often a big difference between observed impact and what we think is should be the actual measure, marginal impact. which means there are these phantom effects. From the naive point of view, the effects may appear to be much more significant than they actually are. The size of these effects depends very heavily on the characteristics of the data set, the scarcity of the resource, the type of classifier used, and so on. And so the bottom line is this idea of how is an individual impacted by group fairness models is very complicated to measure and somewhat, I wouldn't say somewhat, it is very highly contingent on other factors. So drawing lessons then, both from anti-discrimination and for anti-discrimination law from this investigation, I would say, first of all, it's important to keep in mind that the law does permit, at least in the US, permit some race-conscious actions when they're intended to remove arbitrary or unfair effects, and that should be sort of the first question in thinking about race-conscious model building strategies. Is this something that would trigger strict scrutiny, or is this something that would fall on the side of not being considered disparate treatment in the first place? So again, whether it's disparate treatment depends specifically on how race is used in a particular process. I think it suggests that it would be good to better understand what causes bias in machine learning models, and that may matter for legal purposes in terms of determining whether or not this is a form of disparate treatment or simply a matter of removing the source of bias. And then I think we need to think a little more carefully about the actual impacts of different approaches that we take to debiasing models on both the protected groups and non-protected populations. So I think I'm out of time, so I'll stop right there.
That was fascinating. Who has any questions? Right, maybe I'll start with kind of a high-level question, which I've been wondering about for a little while, kind of coming to this as an economist as opposed to somebody from law, which is how we think about kind of this focus on attributing responsibility. And I feel like there's a lot of inequalities that are generated by technology and more general systemic factors, I guess, that we can't really attribute to anybody's particular animus or bias. And so I'm wondering what we're losing by this legal focus on somebody being responsible for discrimination and how you think about that.
Yeah, so that is a problem, and I think that's one of the mismatches, I think, between the way the discrimination law was written and designed and sort of our current situation, which is the law tends to look for a specific responsible entity, right? Whether that's the employer, supervisor who has a discriminatory intent, or the employer who perhaps adopts a test that is not justified and has discriminatory impacts. And so the use of these models, I think, runs the risk of kind of taking forms of either cognitive biases out there or systemic biases, and then sort of pushing them through these systems so that they're reproduced. And the question is, so I think one response would be, well, the employer wasn't responsible for societal discrimination to begin with, so why should they be responsible now? But I'm not sure that that's an adequate answer, because by incorporating these models into their decision-making process, they are systematizing and drawing on these historical forms of disadvantage in ways that they're really sort of scaling them up, right? So there's reason to be concerned about them, but it doesn't solve the legal problem of how exactly we assign responsibility for that, right? So I think that's one of the challenges. I think when the employer is using one of these tools, there is reason to make them have to at least justify it. So that's why when I was talking about the disparate impact earlier on, tweaking the theory so that the employer bears the burden of showing that at the very least that a model they're using has some statistical validity and is substantively meaningful in some sense. because the idea behind disparate impact has been the employer has to justify, if it has a disparate impact, the employer has to justify its use by pointing to some kind of business considerations. And some of those considerations have been ruled, even though they appear to be facially neutral, have been ruled to be a form of discrimination. So for example, if an employer says, I'm going to, not hire anybody that is predicted to have breaks in their employment, that's obviously going to have an impact on women, given the sort of career trajectories of many women and the fact that they take time for caregiving. If we know what the reason is, we can examine that reason and say, wait a minute, that looks like a proxy. That looks like a form of statistical discrimination based on gender. That shouldn't be allowed. And if the employer can just sort of say, well, we just have this model and it just looks like this group of people are predicted to do better and we don't know why, we can't really interrogate those underlying reasons. So that's one of the reasons why I argue that in the disparate impact context, there ought to be more of a burden of justification when these models have disparate impacts.
There's a question from Ruben.
Hi, thanks for a super interesting talk. I just was wondering about the research you were talking about towards the end about measuring the impact on individuals. Was that comparing just the outcomes under the sort of basic model versus the fairness corrected model?
Yeah.
And sort of follow on, is that connected to? So there's been some recent work by, I forget her name now, but it was looking at like how we could quantify individual level probabilities, which is a philosophically interesting question, right? But is it related to that? Like, is it just about observing different?
Is that the leave one out fairness that you're?
Leave one out fairness. That's another related topic.
Yeah.
Think of a different paper.
Yeah, it is. I mean, so I'm not sure if that's the same one. The leave one out fairness, I think, is coming at the question from a somewhat different angle, right? In terms of thinking about the arbitrariness of outcomes, right, for at the individual level, given all this noise that goes on. And so I think it has a somewhat different motivation than our project, but I think the common thing is recognizing that there's some, I'm not sure what the right word is. It's probably the wrong word from a technical point of view, but there's some instability in the models, right? It's that, and the reason I got interested in this question is because in talking to law people and policy people, there's sort of this implicit assumption that, well, there's one model, right? There's one model and it's going to produce accurate predictions. And then we know that it would either predict, success or not success. And that's kind of a fixed thing. And the more that I kind of read and tried to educate myself, it appeared to me that like there is no one model. There's this whole series of choices, and depending on which of those choices you make, even in the sort of before we think about fairness constraints, there are a whole different profile of outcomes that are possible. And so part of this, that's what motivated this project, was to think about that in the context of anti-discrimination law, where oftentimes the claim by individuals who challenge affirmative action programs is, I would have gotten the resource and now I'm not getting it, and therefore I have suffered discrimination. And trying to complicate that a little bit and say, wait a minute, it's not always entirely clear that you would have gotten it. And on top of that, if the reason you would have gotten it is because there's some kind of bias that got built into the system, you're really not being deprived of anything if we're taking that out, right? So that's how sort of we frame the question, but it is related to this idea of the paper on the leave one out fairness in terms of, there's a lot of contingency in these models, right? It's not like there's a single truth that is being discovered from them.
And then there's a question from, do you want to carry on?
No,
I'm there's a question from Yan.
Hi there, thank you. I was wondering whether you believe that one approach one could take to ensure the fairness of an algorithm is to train the algorithm only on data from a single societal group to remove any kind of race, gender, or something, and then use that algorithm. So that should create or I feel like this might create a consistent standard, and then roll it out for the other societal groups. Do you think this could alleviate the problem and be legal in general as well?
So I don't think that that would solve the problem, because one of the things I think that people find on the social science side of things is sometimes predictors are quite different across different groups, right? So that what might be a good predictor of whatever it is you're trying to predict, sort of outcomes for men versus women or for Blacks versus white, the predictors, in other words, if you were trying for maximum accuracy, you might find that very different features are predictive across those two groups. And that just reflects the fact that there are different societal differences in people's experience. So for example, going to community college might look like a very different signal for, again, this is the US context, right? But going to community college before going on to get a 4-year degree might look like quite a different signal for Blacks versus whites in the United States. And so the problem with training the model on one group and then just applying it to the other groups is if it doesn't apply well to the other groups, those groups are going to be potentially being disadvantaged because a predictive model that doesn't really apply to their situation is being used to make predictions for them. There are situations where taking race or gender into account can actually produce more accurate predictions for both groups. And so that's one of those situations where when I had, if race is used at prediction time, is that a form of disparate treatment? ? Because in a situation like that, if it's actually improving outcomes for both groups, it's not clear that anybody's being harmed by the use of race. But we have a very, again, in the US, a very sort of reflexive, well, we shouldn't talk about race. But I think sometimes actually exploring what the differences are, trying to understand them, trying to understand where they come from might help us build fairer models in the long term. And that's why one of the things I'm interested in from a legal perspective is to provide some room for designers and the entities who use these models to begin to do that kind of exploration and to increase our understanding.
Let's do one more question by Joshua and then turn it over to Jeremy.
Thanks. So I'm really interested in the way that you're challenging this idea that race consciousness could be different treatment. Like it might not be different treatment, depends on exactly how you're using it. And I think that combined with like the focusing on earlier causes of the observed disparity would be a way of establishing that. And I wonder also if another way that you could think about challenging this would be to question whether the different treatment is actually an adversity, because it might, suppose I don't gain admission to a certain school, but as a result that school is not segregated. It could actually be the case that everyone is better off in a world in which the schools are not segregated.
Yeah, so I think that is an important sort of policy argument at a higher level, and certainly would be a basis for critique of the narrow focus that the Supreme Court has taken on this, question of, the impact of a racial classification. They're looking at very, very narrowly. I'm not sure, I guess because, as I said earlier, part of what I'm trying to do in this project is to take Supreme Court law as it has been established on its own terms. I'm not sure that would fly with our, in the current framework. I think it's an important argument. I think from a policy perspective, it's an important thing to think about. But in terms of this somewhat narrow space I've given myself to work in, which is accepting existing doctrine, I'm not sure that will work to open up more space, although it's an interesting thought, and I definitely give it some more consideration.
Thank you so much, Colleen.
So that now. Now you should just see my opening screen.
Yeah.
Perfect.
Right, welcome back everybody. And next we are excited to have Salome talk about her paper on confronting inequality in the theory of data law. The floor is yours, Salome.
Great, thank you. Yeah, so my name is Salome Falyun. I'm currently a postdoctoral legal fellow at NYU Law. I'm also joint in a digital ethics group at Cornell Tech. And I'm going to be talking about legal theory today, particularly the normative legal theory behind why the law regulates how data about people is collected and used, and how inequality does or does not feature in our legal theories of data regulation. So in particular, I'm going to be discussing the disconnect in how we think of the project of regulating data flows and problems of social and economic inequality. And a quick note here, when I say data flows in this talk, I really am using that as a shorthand for data about people. So data that is collected about people as they live, work, travel, shop, use things, socialize, and just sort of otherwise go about their lives. And I'm going to walk through the implications of how data governance law encodes entitlements to data, how this endeavor can both misconceive of the problems of inequality to be addressed, as well as place roadblocks in front of how data production may itself be an egalitarian project, and how the law may inadvertently get in the way of collecting and using data to further the study of inequality and to address the inequality of current social and economic systems. So hopefully I'll also connect all of this legal theory to the work of computer scientists and economists and other social science researchers that use computational methods to study and address inequality. So to do that, here's a rough roadmap of what my talk hopes to cover today. I'm going to be talking about why legal theory matters, what some of the predominant approaches, theoretical approaches to data governance are thus far, why inequality should matter to data governance law. Going to evaluate some of the predominant approaches that we have, and then I hope to conclude by sort of prompting my scholarly community and all of us as researchers who care about inequality to take inequality seriously in our legal theories of information regulation. So first, why does legal theory matter? And I want to start here with the example of a legal scholar that I admire a great deal, Gary Peller. And Gary Peller is a critical race theorist, and he wrote this piece, Race Consciousness, in the 90s. And the 1990s, I think he wrote this in 1990, actually. And that was a time period in the US where the sort of conservative US Supreme Court was kind of using anti-discrimination law to undermine and dismantle a lot of the major civil rights era legal victories of the 1960s and 70s. So integrative busing requirements, robust affirmative action laws in employment and education. And Gary Peller sort of revisits in this sort of moment of the 90s, two competing theories from the civil rights era that diverged in their diagnoses of what the wrong of anti-Black racism was, and hence what the appropriate legal responses to that wrong might be. And in this piece, Race Consciousness, he distinguishes between the race-conscious theories of Black nationalism and the race-blind or integrationist theories of civil reformers that ended up sort of prevailing in our legal response of the civil rights era, and that really gave birth to the forms of anti-discrimination law that we see everywhere today, both in algorithmic settings and beyond those settings. And in the piece, Peller explores how this translation of that political and social movement for racial justice into these race-blind as opposed to race-conscious legal agendas, in turn, really kind of set the terrain or resulted in a set of affordances in our existing US anti-discrimination law. And these affordances equated Black nationalist race consciousness with white supremacist race consciousness. And it's this equation of race blindness that was weaponized over the course of the 80s and the 90s and still through the 2000s through to today, by the very groups that the civil rights movement opposed. And this led to our anti-discrimination laws, in Gary Peller's words, marking the limits of their own political project to achieve racial justice. So my talk is not about anti-discrimination law or the history of the civil rights movement, but it does share this larger understanding with Peller regarding the stakes of law's theoretical commitments. So how we conceive of and theorize social problems or social projects in law informs how we enact the legal agendas that enforce or address those problems. Now, there are a lot of theoretical complexities to this basic insight, but at its most simple, I take Peller's work to be a lesson in being conceptually and normatively clear regarding the job of our legal theories in a given domain. So being clear about understanding how a particularly socially unjust process works. So this means what empirical claims about the world that theory rests on, but also understanding with specificity what makes a given social process wrong. In other words, what political or moral claims about the world our legal theories aim to enact. So my thesis for the talk today is that in our prominent theories of why the law regulates data about people, we are not fully confronting the theoretical implications of data as a currency of egalitarian justice, to use a phrase from Jerry Cohen, famous egalitarian philosopher. And by this, I mean that both data production's role in materializing social and economic inequality and the fundamental role that data infrastructures will play in addressing that inequality are not really featuring in our legal theories about data governance. And in failing to fully confront those theoretical implications of inequality, our legal theories about data also, while well-meaning, risk marking the limits of their own reform. So first, possibly an obvious caveat, but because this is a mixed audience and contains a lot of non-legal people, I just wanted to be very clear about what I mean when I say a legal theory. So what I mean by a legal theory is a particular conception of how a political project is realized and distilled into a legal one. So legal theories often offer a particular diagnosis of what makes something harmful and a yardstick against which we could measure current law or proposals to change that law to see if they sort of live up to that theory. So it's a way of evaluating law. As a diagnosis, legal theories tend to lead to a particular agenda of reform that is attentive to the relevant features of the diagnosis of that theory. And again, sort of looks at various legal proposals or existing laws and how they measure up on this yardstick. So what I do not mean are actual existing laws, which may embody any variety of different theories or may, be measured and evaluated against different theories. So for example, we have the Constitution, which is a US law, that is distinct from originalism, which is a legal theory of how to interpret and enforce the Constitution. So originalism offers us a way to evaluate and distinguish correct or incorrect, better or worse readings of the Constitution. And originalism gives us a way against which we could evaluate proposals for reform to constitutional protections, whether or not such, sorry, go ahead.
So just as a clarifying question, so how do you think about the difference between a legal theory and say philosophy of justice or theories of justice? Are they basically the same?
Yeah, so, oh, and thank you for reading out. I'm not monitoring chat, so please feel free to interrupt me if you have clarifying questions. That's a very complex, there are, as you can imagine, much ink has been spilled on the difference between a normative legal theory and a political theory. Here, I would say that our legal theories are really looking at how we would translate or enact a particular political goal or social goal. So it really looks at, if political theories or social theories are ideas of what we ought to do in our world, legal theories are really looking at, okay, what do those implications or what do those lessons mean for how we would evaluate our laws or craft our laws and seek to enact those theories of justice in the world in the forms of our legal code. So in my interpretations of them, I tend to think of them as very closely related, but not all legal theorists take that view. That's a contested view.
Thank you.
Yeah, you're welcome. So now we're going to turn to some predominant theoretical approaches that we see instantiated in the law of data governance and in proposals for how to reform such law. So the first sort of predominant theory that I want to review can sort of be characterized as the legal notion of the right to be let alone. Now, the right to be let alone features very prominently in US privacy, and given that this is the name of an article that is sort of considered to be the origins of US privacy law, written in 1895 by future Justice at that point, Brandeis. And he really kind of characterizes the right to privacy that we ended up having in the United States as this right to be let alone. But this sort of notion of privacy can also really be seen in large parts of EU data protection and privacy law. And the idea here is that data governance in the form of privacy law or data protection law should aim to shore up this sort of individual sphere of sovereignty and autonomy that we have against kind of external influence. So the theory of harm here is that excessive data collection or wrongful data collection and surveillance may undermine or pierce this legally protected sphere of autonomy that we all have around ourselves. And this is intrusive and creepy. It can undermine the dignity of the relationship we enjoy with our inner selves and sort of thwart the necessary kind of close relationship we have with our own inner desires as we sort of form them and come to know our inner lives. But more problematically, this sort of violation can also undermine our autonomy. So if we are subject to coerced consent via dark patterns, this can undermine our self-will and our enactment of that self-will. And the concern here is companies or other entities using behavioral surplus or all of the capacities they have to sort of nudge us towards other behaviors to internalize the goals of surveillors in the surveil and replace our own sense of self with a more programmable, predictable, or manipulable alternative. And so here again, there's really a normative notion of a sense of wrongful legibility, that we're being rendered legible excessively or against one's will. This in turn leads to a legal agenda to sort of shore up or strengthen that sphere of autonomy that we have around ourselves. So this tends to look at how we can establish stronger forms of consent to sort of try to legislate against forms of dark patterns or really make sure that consent is meaningful, as well as to grant data subjects more downstream rights against companies with respect to how information about them is used. And all of those sorts of legal agendas are really meant to reassert the protections that data subjects have to preserve the dignity of their inner lives and expand the protection of individual autonomy against various kind of manipulative or coercive uses. So again, limits on how information can be used to profile a data subject or nudge them towards decisions that data subjects otherwise might not make. And so you tend to see these kinds of agendas in things like bans on adverse automated decisions, increased transparency about how information about data subjects will be used, more rights for data subjects to sort of expand their control over how data about them is collected and how data about them is used. The other kind of predominant theoretical approach to understanding data governance is really this idea of a right to payment. So Andrew Yang, who's currently running for mayor of New York and was a presidential candidate here in the US, as well as Sir Tim Berners-Lee, are both sort of proponents of this kind of theory or view that what sort of the wrong of data governance is one of unjust enrichment. So the point here is to assign data subjects a property right in the data they generate. So they become data owners, property owners, and sort of reassert their property ownership over this valuable resource. So again, here, the legal agenda is to grant data subjects an entitled asset right that they can then sell their data in a market for a price and get money from the sort of techno-feudalist data companies here for the data that they sell. And the idea here is to reassert that ownership right, gives data subjects the ability to command this price and sort of equalize the feudal relationship between data subjects and data collectors. So before we jump into analyzing how these predominant theories do at confronting inequality, I want to quickly pause here to talk about why confronting inequality in data governance law is important. After all, we have many areas of law. So why is it the job of this legal regime to represent, let alone address, inequality? So first, I would point to this chart here. It's a little outdated at this point. I pulled this from the web in February, but in broad strokes, I believe still holds. And the idea here is that data extraction, data collection is part of the story of unprecedented concentration of global wealth and power today. I think we all know the pandemic has been a real boon to tech monopolies, helped create multiple US centibillionaires. And as you can see from the chart here, many of them head up very data intensive companies. So Jeff Bezos, Elon Musk, Bill Gates, as of February of this year, were each worth more than $100 billion. And Mark Zuckerberg at 96 billion is quite close. Prior to this year, Bezos was the only US centibillionaire. He reached that peak in 2018. And if we stick with Jeff Bezos, his wealth grew from 113 billion on March 18th to 189.3 billion, an increase of over 2/3. And if you add his ex-wife, Mackenzie Scott's wealth, the two of them had a combined wealth of over $250 billion. So to put that in more context, if Bezos' $76.3 billion of growth in wealth was distributed to his 810,000 US employees, they would each get a windfall bonus of $94,000, and Bezos would not be any poorer than he was a year ago. So all of this wealth creation, for me as a legal scholar, in and of itself raises questions about whether it's socially desirable for one individual to have discretion over how we allocate such a huge amount of resources. We face choices about the legal arrangements by which we allocate claims to this wealth, and how we place boundaries or don't on how such wealth can be spent or passed down to children, how such wealth is or isn't taxed. And all these are all policy choices. These are legal choices that we make, and we could make them differently. It's also far from the case that this wealth was come by innocently. I think we all are familiar with the stories of wage depression and the erosion of worker protections that facilitate this wealth concentration. Long history of anti-competitive muscling out and buying up of competitors that's going on here, and companies that are operating at a scale and with designs that facilitate communication patterns that have been harmful to global projects of democracy. And the concern here is that the more powerful these companies and their leaders become, the more they can exert their social and political influence. Now, all of this isn't just a result of extractive data collection practices, but it is well established both by the tech industry and tech industry critics that extensive data extraction is a key input, a foundational part of the digital platform business models. So how digital platforms secure consumer surplus from their consumers and other customers, and how digital platforms lock in competitive advantage over their competitors. So this makes data governance law not just the law of interpersonal relationships that sort of governs my relation with another person, maybe a nosy neighbor or a peeping Tom, but also makes data governance law sort of a primary legal regime that's setting the rules of this economic production and governing a key input of the information economy. So in turn, how we encode entitlements in law will affect the economic properties that information has, the sets of incentives that develop around that resource's exploitation or use. And this is, I believe, particularly true of intangibles like information that have no material properties constraining their use absent their legal and technical materialization and instantiation. So doing something about the digital economy that generates this kind of distortionary wealth concentration will require doing something about how these companies collect, process, and use data. But information production is not just an issue of economic inequality. In an increasingly digital and enduringly unfair world, datafication represents one material process whereby a great deal of social injustice happens. So how we become drafted into the project of one another's oppression. Data flows trace the relationships between us and tech executives and venture capitalists that grow very wealthy from surveilling us. But it also groups and classifies us in ways that can enact the societal relationships between us. So information flows can materialize social processes of racism, sexism, xenophobia, and other group-based oppressions in new digital forms. And so here I'd like to consider a recent story by the journalist Joseph Cox, detailing how the US military purchased granular location data from a popular Muslim prayer app with over 98 million downloads worldwide. The app, Muslim Pro, pings its users 5 times a day with reminders to pray. It uses a compass to orient them towards the Kaaba and Mecca, and it uses services to observe fasting during Ramadan and guides users to halal food in their area. So these features helped to turn Muslim Pro into the most popular Muslim app in the world, but it also meant that the app collected high quality movement data about its users, since it relied on location tracking to orient prayers and recommend nearby halal food. So the revelation that movement data for Muslim Pro was being sold to the US military and was now in the hands of the US military sparked dismay and condemnation in the Muslim community. The Council on American Islamic Relations, the US's largest Muslim civil liberties group, sent letters to 3 US House committee chairs asking them to investigate this incident, and they called for legislation in response. Imam Omar Suleiman, who's a prominent Muslim scholar and founder of the Akin Institute for Islamic Research, told the LA Times this sort of tradition of surveillance is not taking place in a vacuum. He noted the long pattern of crackdowns and all sorts of violations of Muslim civil liberties that Muslim community leaders have sort of been pointing out for a long time, and connecting to the violent history of Muslim faith-based surveillance, particularly the expansion of the US drone program under President Obama, which used drones for surveillance and targeted killings in Muslim majority countries and resulted in hundreds of civilian deaths. Zara Ballou, a civil rights attorney and executive director of a San Francisco area chapter of the Center for Islamic Rights, called the revelation about Muslim Pro's data sales a betrayal from within our own community. So the responses from the Muslim community leaders here reflect the social, not merely individual, significance of these data flows. This instance of datafication is wrong to them because it drafts users, faithful Muslims, into the project of their fellow Muslims' oppression. So it takes a digital means for expressing and enacting their faith and transforms that into a vector for what they view as an instance of imperialist violence, materializing this larger social process whereby Muslims around the world understand their tense relationship between themselves as members of this religious group and the US military that has historically and continues to target that group. In other words, what makes this particular instance of datafication, this data flow from Muslims to Muslim Pro to the US military, wrong is that it becomes a material expression of an unjust imperial relation between Muslims and the US military. So how do our predominant theories of data governance stack up on confronting these sorts of 2 forms of inequality that we face with respect to data protection? So first, the right to be let alone, or kind of the privacy theory of data governance. What does it really have to say about economic inequality? Not much. In fact, reducing our claims or our sort of legal rights to information to claims about individual selfhood to monetary redistribution would violate a lot of the normative commitments of this theory. The sort of impulse here is that dignitarian protections are really about anti-commodification. These legal rights tend to be against ideas of reducing data about people to monetary assets. So addressing the relationship between you and a giant company tends to take the form of rights to opt out and against certain downstream uses, but not really rights for payment, which would kind of commodify information that goes against basic normative commitments of this theory. The theory also tends to address this relationship in terms of negative rights. So it gives people, again, rights to say no to certain forms of data collection, but it doesn't tend to give data subjects assertive, positive rights about what sorts of information flows they're subject to, or sort of give an active recognition in how information goals are set. So there's nothing really in the theory of the dignitarian account itself that finds the centibillionaire situation per se wrongful. If these data flows were obtained via gold standard consent, and it was only used sort of in accordance with data subjects' goals and views, there would be nothing per se wrongful about, Mark Zuckerberg or Jeff Bezos or Elon Musk amassing lots of wealth in the process of doing so. On the claims of social inequality, if we consider again the Muslim Pro example, under this kind of dignitarian or autonomy account, the data flow from a user to Muslim Pro to the US military might be diagnosed as wrong because a user of the app would be spied on by a government whose presence in their religious life might have a chilling effect on their activities. And had that user been notified or given the option to opt out of that transfer of data, they would almost certainly do so. This theory or diagnosis of what makes that data flow wrongful, however, says nothing about the larger social and historical context in which this datafication process is happening. It also says nothing about the relational rather than individual nature of this harm, by which I mean how the coerced consent from one user drafts them into the surveillance or potential bodily endangerment of another member of their community. So this data subject dignity account is unsatisfactory to explain the larger social context that makes the sale of Muslim religious activity data to the US military a particularly meaningful and significant act. If we look at the right to payment, credit where credit is due, the right to payment does offer some response to the idea of this unjust enrichment of free data extraction. However, given the realities of this data setting, there are several practical and empirical reasons to be skeptical that individuals alone can meaningfully exert the kind of bargaining power necessary to extract more than a nominal payment for their data. We're talking about data subject groups that are extremely fragmented, bargaining under conditions where an individual's data has marginal value of almost nothing to any given data collector. And again, this setting or this set of exchanges is subject to all of the same concerns over dark patterns and coerced consent that we see in the status quo. More troubling, I think, for this particular theory is this account's prospects for the social inequality problems that are materialized by data flows like the Muslim Pro example. So under this non-payment account, the data flow from a user to Muslim Pro to the US military would be diagnosed as wrongful because users were not being paid by the app or the US military for their data. So if the sale of this data is making Muslim Pro money, then users deserve some portion of that profit. This account, again, says nothing about the larger social and historical context of this data flow, nor of the relational rather than individual nature of the harm. So again, how a coerced consent from one user could lead to the surveillance or endangerment of another member. Even worse, payment might exacerbate the social inequalities materialized by data flows. So payment incentivizes those users that feel that they have nothing to lose or that can sort of benefit from sharing their data for profit to take advantage of that. But this in turn places those with everything to lose or that don't feel safe sharing the information in greater danger. So this increases the benefits to surveillance as winners, those who benefit from its conveniences and personalization, while doing nothing or worsening the risk of harm faced by surveillance as losers, those who, due to their social positions or group memberships that they occupy, face far increased risk of violence, discrimination, or adverse outcomes as a result of these data flows. So to return to the thesis of the talk, that predominant theories of why the law regulates data, we are not fully confronting the theoretical implications of data as a currency of egalitarian justice. Most troubling about the conceptual shortcomings of these theories is that they begin from an assumption that their egalitarian implications, by which I mean how data flows might produce winners and losers, set the stakes of winning and losing, how data production might materialize inequality, that all of this is marginal to the task of data governance rather than central to that task. And in failing to fully confront those theoretical implications of inequality, these legal theories too risk marking the limits of their own reform, resulting in marginal, if any, egalitarian effects. So how might we do data governance law differently? So current theories of data governance, I believe, are sort of faced with three inegalitarian or egalitarian risks. First, laws that are ineffectual against current forms of economic and social inequality being materialized via data production. And so here the idea is that because we're not capturing relevant interests in our data flows and representing choices within that exchange, we are not giving citizens standing to set those structural conditions that determine how those exchanges are set. Second, we have to worry about weaponized individual rights. So here, there's a long tradition, and we're currently seeing it right now in the US in our First Amendment jurisprudence, the affirmative action issues that Gary Peller was writing about, that this isn't really an issue in our data laws now, but the two sort of theories that I highlighted here sort of both risk or are both perfectly amenable to being weaponized by corporate or other powerful actors. So under that dignitarian or autonomy account, you could sort of analogize to how First Amendment freedoms of expression and religion right now are being wielded by companies to dismantle regulation. So similarly, we could imagine strong dignitarian claims about wrongful legibility or coerced legibility being used by companies against the state to dismantle forms of reporting requirements, regulatory reporting requirements that they might be subject to. And if we take the sort of right to payment account or the property account, we can analogize to Fifth Amendment takings arguments. And so these are constitutional arguments that are wielded by companies to resist turning over valuable property assets. And again, if we think of information as property, you could imagine companies using those sorts of proprietarian rights to argue that governments turning over or requiring them to submit information to public authorities or to public research institutions constitutes a Fifth Amendment taking. The third inegalitarian risk that I want to sort of raise here is that misconceiving our data governance laws can risk foreclosing socially beneficial data production. So again, because our law isn't necessarily capturing relevant interests in data production, both in terms of how priorities are being set by companies and how data protection rights are being exercised by data subjects, we could result in the underproduction of socially valuable, even vital information resources. So for instance, if we want to track CO2 emissions or water usage for climate research or resource management, we may not want to defer to really strong forms of individual consent of climate skeptic people in the US if we actually think that there are sort of global geopolitical justice issues at stake in tracking things like the CO2 emissions patterns of people in a very resource intensive country like the US. We may think that the rest of the world's people have just as much, if not more, of a stake in these sorts of data flows. And if our laws don't represent all of those stakes in our data flows, they may not really be adequately represented in how we set our priorities or determine whether or not this type of data flow is permissible. The other notion here is that information and public data infrastructures will likely play a key role in retrieving spheres of life from private market governance. So if people or reformers are of the view that private market governance is not the best way or the most egalitarian way to allocate things like housing, healthcare, and education, then retrieving those forms of allocation from private market governance will necessarily require some positive theory of data production in order to facilitate the allocation and distribution of those entitlements or of those benefits. So taking these tasks as central results in a very different kind of theory of data governance. I offer one sort of theory of that by conceiving of the task of data governance law as setting the terms of our data social relations. And this is an application of relational egalitarian political theories and a long legal realist tradition of focusing on law's role in structuring our social relations. And it takes seriously or sort of aims to represent both the vertical relations between data subjects and data collectors, as well as the horizontal relations between data subjects and others that they share relevant features with, and that make those features sort of relevant to the task of governing data governance, or governing data. The theory of harm here is that not this violation of personal autonomy or a right of payment, but what these data flows materialize. So whether these data relations materialize unjust social relations of oppression, domination, or exploitation. And it also has a distinct legal agenda. This legal agenda favors institutional forms of data governance that aim to represent far more interests in data production and aim to represent those interests in a relation-conscious way. And so this sort of aims to develop priorities and controls that are set for information production that may look quite different from what we see today. So this may result in banning many forms of data production, absent highly controlled settings and legal and technical safeguards against purpose creep. So here we could think of things like biometric marker information or genetic information. It also might look like democratizing other forms of data governance. So here we could imagine things like workplace data or municipal data. And finally, it might facilitate and encourage other kinds of data production that we're maybe not producing enough of right now. So here one might think about, again, climate data, fine-grained details about people's resource consumption patterns, or also far greater information and clarity in international financial flows. Hopefully this also sort of suggests why getting our legal theories right is a sort of a good segue or bridge between the agenda of legal theorists and the agenda of economists and other researchers who aim to develop egalitarian responses to the current world. The current status of our data relations are largely unequal, but like our analog social relations, they don't have to be. Just like data can materialize injustice, our data flows can also materialize just social relations. And like the law itself, data relations will likely play a key role in facilitating how we address inequality in the digital world. And that includes much of the machine learning research being discussed here. There's also here a central normative egalitarian agenda to this legal theory, just as there is to this line of inquiry or computational research, that the goal of data governance law should be to develop legal institutional responses that equal these relations, and that in turn foster the egalitarian role that data can play in equalizing other areas of life. So with that, I'm going to stop my screen share and hopefully open the floor up for some questions. Thanks.
Thank you, Sonia. That's great. Who wants to go first? Let's go first again. Oh, hey, Abby, go ahead.
Hey, great talk. Great to see you.
Hi.
I was wondering, you mentioned a little bit sort of like the relational power within these. Could you talk a little bit more about that?
Mm-hmm. Yeah, so actually the paper that this talk stems from spends a great deal of time talking about why sort of this relational aspect of information production that currently doesn't really feature in our theories of why we govern data it is very central and should play a far more central role in how the law thinks about representing interest in information. So by that, I'm kind of making an empirical claim and then also a normative claim on top of that empirical claim. And the empirical claim, to start with that, is that when data is collected about me or from me, it is never simply just about me. So you can collect data about me and it's like, okay, Salome, she's a woman, she's a millennial, she's a cat lover, she recently bought her cat an expensive Japanese ceramic cat bowl. That isn't just sort of used to make predictions about me and my consumptive behavior. It's also used to say, okay, there's this other millennial woman out there. She's maybe also likely to buy this cat bowl. And so when we're thinking about the interests that I have and how my, millennial woman cat loving data is being collected, I'm not the only one with a potential stake in how that information is going to be used. People who share these relevant features with me also have a stake in how that information is going to be used. And so legally, when we try to reduce all of the interests in that information just to me and my sort of contractual relationship with whoever's collecting that information about me, Google probably in this example, there are all sorts of relevant interests of other people that our law just isn't representing. And so it's not featuring in how we think about what kinds of information we allow, what kinds of information we disallow. And that's kind of the general empirical insight here. where I think that sort of glosses into a normative insight is to say, you know, we have issues of lack of representation, so different interests aren't being represented. But that doesn't just flatly implicate all sorts of people equally. You know, it's one thing when we're talking about like my millennial cat bowl purchasing. It's very different when we talk about, let's say, information about whether or not I'm in the first trimester of a pregnancy. And now that's going to sort of implicate very different kinds of social facts about me that may be far more vulnerable. And in turn, if that makes someone else, a prediction about someone else's first trimester pregnancy more likely, or sort of facilitates those sorts of predictions, we're dealing with like normatively distinct kinds of concerns with respect to those sets of interests not being represented and how we think about how we regulate and allow that kind of information to be collected and used.
Right. So I guess I have a big picture question also, which is like, I guess when I think about machine learning or AI more generally, I guess you can think of a lot of it as optimization or maximizing some objective function. And then I guess like control rights over data or ownership of data really translates into picking the objective function, right? If Facebook controls the data, then Facebook uses it to maximize ad clicks or whatever. Mm-hmm. And so I guess I was wondering if you have thoughts about possible alternative legal regimes in terms of redistributing the control rights over data, what that does in terms of changing the objective functions that actually used AI is used for.
Yeah. So again, I think that when we take far greater interests, when we sort of represent a far greater set of legal interests in how we think about governing information, one thing that very naturally follows from that is that the set of information that we would allow a company to make exclusive, you know, their goals and their priorities, to set sort of the exclusive agenda for how that information is collected and managed and used, and towards which objective functions we're optimizing, would probably shrink a great deal. And so that looks like forms of governance that sort of represent far more interests in that information. And so what that specifically means in terms of a legal agenda can depend on the kind of information we're talking about. So that can translate into a legal agenda that says, okay, Facebook has a limited monopoly interest in the information that they collect. They can exploit that resource exclusively for 5 years. After 5 years, that information reverts into a public institution or public data institution that manages that information, and that researchers can apply to gain access to and can explore all sorts of other social questions, or competitors perhaps can gain access to that information and try to develop competing products. But we no longer, as a sort of state, recognize a sole ownership or proprietary claim in one company to determine the how that resource is going to be exploited and used. Another form that it might
your
take,
ideal would be like public ownership of or public repositories of data, or
for certain sorts of information, but in other settings, information sort of institutionalizing a greater set of legal interest in information might look like giving labor unions an explicit bargaining right over the forms of workplace surveillance that they're subject to. So you could expand the sets of labor protections that we have to say that one thing that worker unions can bargain over are the forms of surveillance that they're subject to, and in turn impose onto their employers. So that might be the form that you might see for institutionalizing a greater set of legal interests over workplace data. You could imagine municipal data that if a ride-sharing company wants to operate in the city of Ann Arbor, where I'm based, they have to apply for a license from the city first, and all of the information that is collected needs to go through an intermediary that sits at that municipal level data kind of repository, and the city can use that to study their traffic information, set priorities for how they're going to develop and invest in infrastructure, and maybe reevaluate whether or not allowing these companies to operate in the city is good or bad for the various political goals of the city. That's another way that it might look. So it really kind of depends. But the basic idea theoretically is that these interests are not reduced to that individual exchange between a data subject and a data collector. There's a lot more happening here.
So like having collective institutions that manage them. In
Yes,
some form or
far
other.
more collective institutions. Yeah.
Abby Adams.
Oh, we have two Abbies.
Yeah. I'm sorry if this is a stupid question, but I was wondering, so you're talking about data collection a lot of the time, and some of the kind of problems that you identify seem to be more about the way that the data is processed. And of course, the way, like, the ownership and the way data is collected is likely to influence the way that it's processed, because people are going to have to give different types of consent. But it kind of seems that they are logically distinct, and like there are certain things, how can I put it? I guess what I'm thinking about is, you know, in a more benign setting. So I'm thinking about data like administrative data collected by the state, which at the time was kind of is like secondary to the core purpose of data, of why particular forms of data was processed, as it was collected in the first place. But ex post has actually become really important for understanding particular phenomena, like from the perspective of research. And so that would point more at being concerned about processing as opposed to collection. I was just wondering if that was a silly distinction, or how you thought about it.
Yeah, no, I mean, there are people who get into all kinds of nitty gritty about, like, do we regulate data collection? Do we not care about data collection? We only regulate data use. I tend to really think about them as deeply interconnected, and I tend to take a holistic approach. So I'm probably flitting in this talk between, like, looking at data collection, looking at data use. I tend to think that the normative relevance that goes into how we would restrict or set the conditions of data collection are inextricably entwined with the uses that we anticipate for that information. And yeah, let me think back a little bit on your question. I mean, I also think that, I mean, one of the benefits of sort of thinking more institutionally about information is that you don't kind of have to break it off into this like one-off thing where you like either give your consent for it to be collected or not. You can tend to think about managing information production, information resources with an eye to, okay, if you want to use this to measure impacts on climate, go ahead. If you're going to be trying to create like a competing industry with the company that we gained the repository of this information from, maybe we have like we hold you to a higher standard, or we regularly check in to make sure that you're not using this information in an inappropriate way. So you can start to think about kind of tiering or managing your access to information based on the goals or the purposes of use. But you can also start to think about how you would implement those sorts of institutional controls around different kinds of information being collected. So again, you could think of information being collected around workers or in the workplace, going to a different kind of institutional repository to make those decisions about use that might be distinct from the types of institutions that are sort of managing and sort of setting the priority of those questions if we're thinking about like the municipal public trust. So that was a little bit of a jumbled answer, but I think what I'm trying to get at is that I think both collection and use are normatively important for the law to think through in terms of how that hashes out in terms of, you know, what interests we represent and how we represent them. But I tend to think that collective institutions offer us a more coherent way to kind of like balance the interests we might have at the point of collection and balance the concerns or the goals that we might have around use.
No, that's really helpful. Thanks.
Yeah, thanks.
Abby?
I'll have plenty of time to talk in a minute, but I just wanted to mention I guess this relational level of, and thinking about sort of intervening on collective institutions, if you're thinking about that as a way to sort of intervene on markets. I'm also thinking about sort of like Lena Kahn's work on Amazon, if this is a way to sort of, at this point, to sort of like an empirical strategy to think about how we sort of potentially measure harms. Yeah, absolutely. I mean,
I think that thinking about our rights to information relationally or collectively, one, just like empirically maps on to how information can benefit and harm people. Two, I think it also goes more accurately represents the way that information creates forms of outsized market power for certain companies. And I mean, to be honest, reverting large stores of information resources that are currently being legally defended by like a weird and flimsy reading of trade secrecy law into the public right, into the public domain, or in various forms of sort of collective institutions would significantly undercut a lot of the sort of monopoly power that these companies currently enjoy. We can have a long discussion about how I think antitrust approaches do and do not achieve that, or how they kind of interpolate into an agenda for developing data institutions. But yeah, maybe I'll leave that there for now.
And to be mindful of time, the last question is Ruben.
Thanks.
Hey, Ruben.
Hey, thanks. I'm a really big fan of the paper that this talk was based on, and the talk really helped illuminate some of the issues, and you brought some interesting new examples to the table. So thanks for that. And my question is about like to what extent is your argument kind of based on a critique of data governance from a rights, sort of, I guess, individual rights perspective? Is it that like some of these values could be better protected if we move away from an individual rights perspective? And I guess thinking about like other critiques of even individual rights, which are supposed to protect kind of egalitarian norms, like, you know, rights to education or healthcare or things like that, is part of your argument that like trying to think about egalitarian data governance in terms of individual rights is the problem, or is it something different to that?
Yeah, I mean, I always joke this paper has undergone a painful metamorphosis from a political philosophy paper into a legal theory paper. And in its earlier larval state as a political philosophy paper, it was absolutely engaging with a lot of work that sort of it is a critique of an individual rights approach. I think in its current form, it's less a critique of individual rights and more a critique of individual data subject rights. By which I mean that you could very well say that we all have like individual political rights to mutual self-determination of our data institutions. And those are individual rights of political standing and political recognition in setting the priorities of our information resources, to which purposes they are being used. That tends to sort of govern all of our political institutions in a liberal state. But they're not individual data subject rights. They're public rights. So we all have standing. And, you know, again, here you could say we all have standing in the mezzanine level institution as workers. We all have standing in the mezzanine level as like people who may become pregnant. You know, you can break that into mezzanine level institutions or groups. But as a legal agenda, it still probably contemplates individual rights. They're just different kinds of individual rights, political rights, as opposed to kind of personal or transactive rights.
Thanks, that's really interesting. Thanks.
With that, I would like to turn over to Abby, who is going to talk about measurement as governance.
Let's see if I can get this to agree. So you should see the overall slides. And now if I go into presenter view, do you see the notes or the actual slides?
We see the notes.
Now?
Better.
Okay. So that's correct. All right. Just a title slide. Excellent. Thank you so much. Delighted to be here. The talk's been super interesting. I was able to attend yesterday and sort of reflect a little bit on sort of where I sit. Where with these different communities. And I guess I can't see the chat at the same time, so someone else will watch. We're in the setting of, talking about what I'm going to call fairness-related harms. And so this includes sort of the allocative type examples that we have seen plenty of already and will continue to see in the news, as well as the kind of sort of representational harms. For instance, when this went viral of who gets shown in various Twitter photo croppings of, sort of what is considered salient in a photo. But regardless of sort of allocative or representative harms, I want to say that we can sort of often end up talking about sort of biases in machine learning, but really we're most concerned about when these are actually harms of some form and when they're sort of fairness related. And this sort of accounts for the fact that we might have different sort of different understandings of what we mean by fairness, which I'll spend plenty of time talking about, but sort of really helps us reimagine what we're trying to get at when we're thinking about diagnosing or preventing or mitigating these harms. It also brings back sort of power into the situation of sort of what decisions are being made when and where those impacts go, and helps us move away from, say, technical only types of solutions. So we're going to have these kinds of harms. Inequality exists. This is going to just sort of show up at some point somewhere, always somewhere for someone. One of the things that makes this challenging that has sort of already been discussed to some degree is that we're thinking about both these sort of like structural differences as well as sort of individual level harms. And so how we protect against those or how we reason about them or how we sort of detect their presence might be different. But often it's still useful to sort of account for the fact that certain harms exist or the degree to which they exist, which can be helpful for getting them intervened upon, sort of proving that they exist, showing the degree of this inequality, showing that, interventions are required. So, so we still want to typically measure that. And so, sort of signaling of where these harms can be assessed. We have all these sort of different methods, heavily drawing from the social sciences here on how we might detect fairness-related harms in computational systems. And then also, like many of us have spoken today, how we might think about countering with interventions through different types of mechanisms, and also at different levels from the design process of a machine learning model up through sort of large-scale legal and regulatory mechanisms. So these are sort of how we find them, how we counter them. But I want to make a sort of specific claim about where fairness-related harms emerge. And I'd like to spend a little time building on some past work and then sort of pointing to some future directions about how fairness-related harms emerge when there is a mismatch between the thing we purport to be measuring and the thing we actually do. So this is maybe not a controversial thing to say. I would say that this is actually important in that into what it reveals about the kinds of systems we think about. And so I'll define all of these terms more in depth coming next, but just to set this up, in social science world where we have these tools, again, to sort of assess and measure and model interventions on fairness-related harms, we actually have this really nice process where we have, we might have some hypothesis, we're thinking about some kind of social construct. I'll define these. We operationalize it somehow as, there is something that we're using to represent this idea, this sort of squishy underlying construct, and we believe that this construct affects things in the real world on which we take measurements. And so we have sort of a long history in the social sciences of trying to assess these harms, trying to sort of think about measurement of these underlying social constructs. And so in some ways, it's quite straightforward then to be thinking about where these fairness-related harms might emerge. So yesterday, Reddit spoke about, if you're trying to think about the construct of poverty and you represent that with income, you're necessarily going to be missing sort of significant issues about, say, wealth, something that's missing from the operationalization. Maybe by poverty, you actually in the construct mean precarity. And so maybe there are other aspects you want to be bringing in within that. So again, sort of within this sort of social science world framework, it really sort of makes clear where sort of fairness related harms might emerge and how we might address them. However, machine learning world in practice is not like that. And that's not to say that we don't have sort of clear pipelines of pre-processing and training data and test data, but it's that the sort of construct operationalization measurement process is just so deeply entangled within all of this. And it really sort of means it's much harder than to diagnose or name or label what might be happening and where we might see the potential for those harms, or even just understand harms that have already happened for assumptions that have already happened at various stages along this process. So part of why this work we argue is critical is that we actually need this language. We need to be able to tease apart these different ideas, and we need to be able to uncover the existing assumptions in the systems we're concerned about, where we're concerned about fairness-related harms. And fortunately, we do have the sort of the tools, the framework of construct validity as a way to sort of actually generatively sort of poke at what we think is going on in the system and where we think these mismatches might be and where these potential for harms might come from. So again, I'll define everything a little bit more, but just on why this is so hard and also important. And several people have alluded to different parts of this already. But, in this tangled mess, sort of who is making choices about what the thing we're trying to represent, how it gets encoded, who gets affected, how we can sort of contest those results. All this really obscures different sources of power. Assumptions are really very often implicit. They're just, not even worth documenting. There are strong feedback loops, which I'll talk about, ways we can use this to think about feedback loops sort of within and across systems. We also understand that these are sort of not simply technical, not simply social, not simply organizational problems, but really in a non-separable way. These all interact with each other in really important ways. And sort of fundamentally, something that we'll return to is that what we measure changes what we think we understand about that measurement, about the sort of the problem at hand, where harms come from. And so just a quick note on context. I guess I'm coming from my PhD in computer science, but I work heavily with social scientists. And there are these two sort of newish fields of computational social science and fairness, accountability, transparency, and socio-technical systems. I would argue there's a very significant overlap there where we're thinking about these large-scale social structures and trying to understand social processes in, again, what I'm calling socio-technical systems, where we really can't completely separate something being sort of a purely technical abstract in its own system from the social context in which it's implemented, embedded, assumptions are made, and so on. So that's sort of where we came into this work. So I want to first talk about, sort of untangling this mess, bring in some language from the social sciences. So some of this language will seem familiar, but again, because often this is not explicit, we have to sort of unravel what has happened in our systems. It's really important to be able to be precise about what we mean. So, we might care, basically almost everything interesting we care about. So if we're trying to determine who to give a loan to, or who to kick off a platform for their toxic language to, or how we incentivize people to stay in their Facebook group, what counts as pro-social behavior, what counts as fair. These are all examples of unobservable theoretical constructs. And that's just true, but we've measured them anyways. But so to do so, to measure these unobservable constructs, we operationalize these constructs with a measurement model. And so I'll sort of walk through some examples of what this looks like. But this is crucial because, again, this is happening whether we acknowledge it or not. These are things that we have operationalized and use in practice. And this is extra crucial because, again, whether we acknowledge it or not, this encodes our social, organizational, cultural, political values. So we can't just sort of be the remove, just an engineer, because these are sort of necessarily happening and nested. So as I said, we have some kind of unobservable theoretical construct. From that, we take the operationalization. From that, we get to observe these measurements. I've already asserted that the fairness-related harms really do emerge from mismatches within this process. And that specifically construct reliability and validity help us interrogate what's going on here. So this will be something generative. So let me first give you some examples with some mismatches in the process, and then highlight what tools we have to break this apart, and then sort of show where this takes us. All right, so sometimes we think about this as sort of a silly example, but I want to first talk about height. So if you'll bear with me to treat height as some kind of unobservable theoretical construct. At face value, this might seem like actually a really simple, what we might call a sort of a representational measurement. It could be represented by, with respect to other physical objects. But maybe if I'm actually talking about people, I might say, okay, I'm talking about sort of the height of a person. That's unobservable theoretical construct. I'm going to assert that I'm operationalizing this with my latent variable h, and I'll take sort of measurements using a ruler of what that looks like. So we might generally agree on that. However, there might be some things actually when I talk about the height of a person that maybe might matter depending on the context I'm using this in. We talk about babies in terms of length. And if you sort of primarily use a wheelchair, I might mean something else by your height. And so when I'm sort of making decisions based on height, I might use that. We can also use this to think about where, for instance, measurement error potentially associated with certain kinds of sensitive attributes. We can already think of examples of disability, but you can think about even in processes of data collection. So in the social psychology literature, there's a nice example of, might be one thing if I sort of ask us all to measure ourselves with rulers. If instead I use data from an online dating site with self-reported height, what you'll end up finding is systematically biased data where we observe that men over-report their height on average. And so what we get is something that's like correlated with this, sensitive variable, but sort of emerged in this kind of maybe neutral way. So anyways, by articulating these assumptions, we start to get sort of the language to pick apart where we think these things might be coming from. And so when I say height, do I actually mean, sort of who am I including? Is that relevant for this context? Can I understand what's going on? So that's one. This is a running example in our paper, but I'll use it a little bit less since Rediet gave a beautiful talk yesterday, trying to think about poverty and what you get between, in her case, she was talking about operationalizing poverty with income. Here I'll talk about socioeconomic status, which is, sort of is a common construct in the social sciences, basically thinking about sort of position and opportunity. And so here we'll use a common operationalization, which is income. And then I'll take measurements of income. We could also call income as a proxy for SES. Proxies are just measurement models. And of course, income itself has to be measured and so on. So this might be great. This might sort of seem reasonable. I might run into trouble if I'm, say, ignoring the impact of wealth. Again, if we're sort of concerned about downstream incomes or who's sort of precarious or likely to need a certain type of benefits, perhaps my income will report that I appear to have a sort of huge influx this month, and maybe that means every month that's true, but maybe that's actually my payment for the 6-month project. So this helps us think about what we might be missing in what we are trying to get at with SES and health, with SES and income. We can also think about downstream effects. So I might try to ask questions about the relationship between SES and health. And in general, income might be a good proxy. Maybe here in Ann Arbor, where there are lots of college students who might report having a lower income but have great access to healthcare, maybe that would actually sort of not be the right model there. And then finally, we can also get at other sort of data issues. For example, in the UK, Human Rights Watch reported on a benefit system that used income to look at whether or not you're eligible to enroll for certain benefits. However, basically based on what day of the month you were paid, it would estimate your annual income differently, which meant that if you enrolled on a Monday versus a Wednesday, you might sort of qualify or not, which is really not the kind of what I'll call reliability that we want to ensure. And then just 2 more quick examples. There's a classic example of teacher effectiveness, the education value added assessment model in the United States that's been used to evaluate teachers, to fire teachers. And if we trust that, the differences within subject for a group of students within 1 year divided by the fraction that's teacher, with a few other limitations, that is the entire full assessment of the quality of a teacher. We're going to make sort of very different assessments as opposed to teacher evaluations, how they relate to the class, who's in the class, what kinds of needs are in that class. Perhaps we're looking for something else. And then I want to highlight this work particularly by Obermeyer et al., where they're looking at auditing a healthcare management program, or rather computational system to determine who should be enrolled in such a program. And so what is actually happening is this program is trying to decide who would have the most patient benefit from this enrollment. This is operationalized as some latent variable P, which is sort of this idea of future care needs is patient benefit. That's represented as future care costs. And this is actually learned using models based on past care costs. And so what you find there is because past care costs are being used to represent effectively past care needs, those who have systematically less access to healthcare will appear to have lower costs. And so what this results in is Black patients being sort of systematically excluded from these kinds of systems. So again, this can sort of seem nice and productive and obvious, maybe even coming in this direction once we untangle what's going on, but we need to be able to lay this out in order to understand. And just to sort of show that we do have some tools to, it's all easy for me to, in retrospect, come up with these stories. But I do want to say that, this is something that is specifically generative. And so I'm going to mention sort of construct reliability and validity to help identify where these assumptions are happening when we're thinking about the kinds of computational systems that we are worried about harms emerging from, and how we can use this to both understand things that have already happened and use this as a way, as sort of a framework to think about what could happen in the future. And this sort of generative point, I think, is important because it's not just sort of a closed checklist in some format, that here we actually have sort of a set of thinking tools. And so I'm going to introduce some language, but really it's about, here are the types of questions you get to do to investigate sort of what's going on in the system to try and sort of, again, diagnose, mitigate, prevent fairness-related harms. So first, again, I won't spend too much time on this. There's we have a paper on this, we have a tutorial on this, there's a video of this. You can see me go into depth about all of this elsewhere. But one notion is just on construct reliability, which in our case looks analogous to precision statistics, which might look something like, again, if I enrolled on a Monday or on a Wednesday, I would assume the same thing to happen for my benefits. This is actually a common task in computer science under the umbrella of out of sample prediction, which is really just sort of if I ran it again on the same kind of data, do I get the same kind of answer? Construct validity is something that here we're actually pulling from a bunch of different traditions, from political science, education testing, especially education testing and psychology, for the fairness, accountability, transparency, and machine learning community specifically. And so I won't go into the sort of the types of validity we put underneath the umbrella of construct validity. And, I will say we end up with these 7 types. I will say, to some degree, or rather, no, I will say fully, I don't actually care if you use these precise labels. This isn't about, can you name, oh, it's this type of bias or this type of bias or this type of validity or this type of validity necessarily. What I primarily care about is, can you show these different types of evidence for what you're doing? Does it work? Does it work well? Are we able to identify the kinds of mismatches? What kinds of evidence are we able to show that sort of we're doing what we think we're doing? And that's really non-trivial. And so basically what this provides is, here are sort of the sets of questions I can ask to try to get at, like, okay, does it seem sort of reasonable? Has face validity. Okay, what do I actually think about what this construct means? What am I representing? Can it be represented? Does this match what I think it does? Content validity, and so on. So this really, again, just gives us a sort of a generative way to sort of break down, if we were to look back at our examples of, okay, we have this healthcare system, what's going on? We could use this to sort of unpack, okay, we're trying to think about patient benefit. Okay, we're thinking about patient costs, what's going into that, what's missing, what's outside of the model I would want to pay attention to, and so on. And you may have already noticed there's one of these that looks sort of different. And that's consequential validity. And that has a sort of strong normative sounding name. And I really want to spend some time on it because it is sort of different. It was sort of brought into the validity world separately. And this includes a bunch of different types of ways of thinking about these kinds of feedback. So several of us have already mentioned Goodhart's law and Campbell's law. This includes ideas like, when a measure becomes a target, it ceases to be a useful measure. Washback includes ideas like teaching to the test. If I know that I'll be evaluated based on how well my students do on the test, then I'm going to, emphasize that rather than maybe something I think is important otherwise. This shows up in economics and through the Lucas critique, a lot across the social sciences. That's performativity, of where basically the thing that we are defining then changes the system we are interacting with. And I really like this quote from David Hand, who writes a lot about measurement, where he says that measurements both reflect structure in the natural world and impose structure upon it. And I think that's really important for our setting, especially in these sort of machine learning or technical settings where we're often concerned about sort of these, say, categories getting encoded into systems. And there's an appearance of objectivity. There's an appearance of just, this is just how things are, how things are implemented. This is just sort of a bar you need to pass through in order to move forward. So I'll spend a little more time on this because I think this is a really powerful way to start to think about these consequences. And I'll say why, from the educational testing literature from Samuel Messick, why this is argued to be part of construct validity itself and not a separate downstream thing, is again that the fact that what we measure changes what we understand about that measure. We are changing the meaning and how that is interpreted by doing this. This really then means, because we are changing the system that we are sort of grading this measurement within, it means we have to consider that in its initial sort of, can we assert that this is valid, you know, when the measure becomes a target and so on. So pivoting slightly, I just want to use this framing to talk a little bit about fairness, touching on some of the discussions from the past 2 days. Ruben's talk was a sort of a full talk about egalitarian justice and that construct itself and its substantive nature. And in general, when we're thinking about fairness itself, an unobservable theoretical construct, especially a weird kind of unobservable theoretical construct about which there have been millennia of disagreement about what it means. It is essentially contested in that it doesn't have one true shared meaning. It might be context specific, culture specific, time, person, context specific. So we're never going to have sort of one agreed upon definition, but in different kinds of contexts, we're going to say, we are calling this fair. This could be a problem if when you say fair, you mean this, and I mean something else. That might be as kind of mismatch in our theoretical understandings. Also, thinking about consequences, if you are telling me that this is a fair hiring algorithm, then to me, that sounds like you're offering me a fair hiring algorithm. So when we call these things, say, fair ML, you know, we really have, you know, that's a really strong label. So we really have to pay attention to and be wary of sort of how we use these labels as well. Again, this is not unique to sort of, fairness in itself, but here, you know, we might be concerned about notions of justice instead. Many of the sort of disagreements in the literature about what's already been mentioned, kind of individual versus group fairness. Often this is held at sort of the operationalization level of, you know, I'm measuring predictive parity or whatever. But often the sort of underlying argument is really about differences in what the underlying values between different types of fairness are. You know, do I care about sort of the individual or the group and the logics behind that? And so if we hold the disagreement at the level of operationalizations, we sort of are obscuring the values that we're actually arguing about. It makes it much harder to disentangle when something has gone wrong. Individual fairness is sometimes mentioned as an alternative to group fairness. This is the idea of effectively like treating, you know, someone who is similar to you in a similar way. I would argue that this requires knowing a lot about individuals, perhaps more than we could ever know about sort of the individual experience and how that maps to another, whether that's, you know, my true employee quality or my just difference from someone else, what we would each get from being treated in a certain way. And so that kind of sort of assumed richness of that kind of observation is a really important challenge to thinking about sort of what it would mean to implement this or use it, and again, sort of treat it as fair without question. And so often we like to sort of say, assume we have the perfect measure of similarity, quality, et cetera, but you're throwing away a lot of the assumptions in the process. Group fairness itself also has problems where you have different ways to operationalize this, as others have mentioned here today, reflecting different theoretical understandings. I'll defer to some of the political theorists and legal scholars on many of these points. I just want to sort of make clear how these conversations connect. And then also, of course, we know that group fairness might depend on sort of putting people in different demographic buckets themselves into buckets that are themselves often essentially contested, extremely sort of socially constituted in a way that means that when we sort of assign someone to a particular label, we are then potentially doing something to that person. We are potentially creating harms that go along with inferring or assigning and creating these groups. and that when we say implement something as, say, my system requires that I check the box M or F in order to create an account for something, I have somehow built in a sort of a mandatory gender box for anyone who wants to use the system. And so we're really, in a way that might seem subtle, building in all of these very strong assumptions, these measurements all the way down. So I already mentioned this, but I just want to be clear that, fairness itself, we're not going to solve this one. It's essentially contested, but to the degree to which we are still choosing to claim that things are fair, we just need to be explicit about sort of what we are operationalizing, what the underlying values are, what we actually mean, and where and how it applies. And so that itself isn't necessarily controversial, but it does mean, we are making these significant decisions when we're making these choices. And so we just need to be clear about which disagreements are at, say, the operationalization level versus what values we're actually trying to reconcile. And so taking this as a way to understand, really sort of bridge a lot of the talks that we've seen already, thinking about measurement helps us think about how we understand harms and what we're actually trying to get at here. Blodgett et al. Is a really wonderful paper looking at natural language processing examples specifically, but where effectively debiasing doesn't necessarily address the types of harms that we're actually interested in. By actually sort of bringing to light the values being decided and how these systems are implemented, this actually helps us think about actually what are organizational or legal or procedural kinds of interventions as well as technical interventions. Again, in our tangled mess, this helps us change what questions are getting asked, helps us understand where decisions are being made. And so I'm not the only one to be enthusiastic about this. This went viral and I loved it, about how when you include the measurer, that this is a sort of a social process, and that we don't have our sort of like scientists and engineers making non-normative decisions, that we actually have these larger processes at play. And so just zooming out on consequential validity, we're really dealing with these highly durable social structures, which adapt and unfortunately get obscured by these sort of technical governance decisions where we just have, again, our MRF checkbox that we needed to get into the system and so on. And that, this idea that we have these constituted and constitutive constructs is really not unique to this, that we actually have a great deal of scholarship thinking about, for instance, how race itself is a technology and how it gets sort of created and encoded and reinforced in certain ways, different contexts. This happens with, anyways, we have a significant literature across the science and technology studies, sociology, and beyond to think about how we understand these socially constituted nature of things being measured. But this means we're still thinking about consequential validity, and that, again, when we are sort of assigning, say, people to a group in a certain way, and that becomes how the group is defined, this is, again, sort of within this larger feedback system of measurement. And so why does it sound like I'm being pedantic about this? I would argue that it matters because we need this language in order to unpack what's going on in these kinds of systems. We don't get to live in the sort of clean social science linear world. Measurement is everywhere, basically everything we're doing and care about, and the harms that we are most concerned with and why we're here today are the ones that emerge from mismatches in the measurement process. We do have tools from construct reliability validity to help us interrogate those. taking the full version of this quote, language is power, life, and the instrument of culture, the instrument of domination and liberation. Consequential validity is one lens that lets us bring in this sort of systems level feedback and helps us reconcile these different understandings of risk, systems, and social structure. So I know I have 2 minutes, so I'll just skip most of my last slides. But I just want to mention that, there are lots of ways that we can use this to try to make progress. Some of this work I'm doing is thinking about how we can think about risk and harms, where again, sort of things that we might think of as AI accidents are actually glitches that reveal some kind of underlying social structure. This really sort of points to a need for these kinds of structural explanations, but places where we can learn from other types of settings that have already been concerned about these organizational, cultural, technical settings where the issue is not risk necessarily, but power. A cool project I can talk about offline is on the Havana StreetNet, which is, again, sort of trying to bridge the individual and system level type of setting. What's fun about this is, this is a sort of, we can sort of physically see the wires between apartments, and it really highlights the kind of sort of social, organizational, political processes going on that underlie this sort of important infrastructure. And really broadly, this is sort of always happening. It's not usually so explicit, but when we study this, we can see how, depending on which levels we're looking at, we really sort of change our understanding of how, for example, inequality gets encoded in this kind of system. And so really by being able to look at sort of case studies like this, we can really sort of think about frameworks for understanding processes that happen both at the individual and system level. So those are just some fun things I'm thinking about. Measurement is everywhere. I think this is just something we need to keep in mind as we're thinking about how we understand risk and systems and social structure and bridging across these sort of social and technical fields. So I'm at time, so thank you so much.
Thank you, Ellie. Who wants to ask questions? Ruben.
Thanks for a really great talk. I'm really interested in this, in the idea of applying construct validity to solve problems of fairness, and I wonder if one of the reasons why it feels kind of like it's going to result in, I don't know how to put this, but it rubs up against the ways that the deployment of ML in practice wants to be a science, but it is a political compromise. So I guess what I'm trying to say is, so the psychologists who invented this notion of construct validity were kind of concerned with are the things we're measuring what we mean to measure, and can we compare between different experiments to be sure that we're measuring the same thing? Whereas the constructs that are being used in ML systems to do things like allocate jobs, the construct might be something like merit, which is not a kind of a component in a theory that psychologists are trying to discover, but it's like a compromise that has been built up over many years that obscures many political questions which people would rather not deal with. Does that kind of raise a challenge to the use of construct validity as a means of addressing fairness issues in practice?
Yeah, that's a great question. And in some ways, the answer sort of depends on the audience. And so, this is not the version of the talk that I necessarily give to all social scientists who say like, yeah, of course, like, sure, whatever, constructs. With computer scientists, which is sort of much more the sort of audience we're intervening upon, it's a way of unpacking these social, etc., political processes that are underlying the things that are already being done. And so in this work, we sort of spend a lot of time unpacking individual examples of like, like, let's look at the system, what assumptions are being made, how do we understand it? Really, it's just about being a good computer scientist to do this model well. And here's how we can unpack what's going on in a way that just helps us sort of unpack what those assumptions are in a way that is not, again, sort of is not just sort of like a fixed checklist, but is in a way that's sort of participatory and generative. So I would say we're trying to use it as a point of entry to allow for acknowledging some of those assumptions, especially because contract validity, you don't necessarily need the sort of fully theoretically motivated construct in order to get there. In some ways, it's also fine if you're sort of starting with like, here's what I'm asserting this construct is. And now, given that assumption, here are the assumptions I'm making on how that's represented. So, but yeah, I think that's a great point. So.
Thanks.
Jeremiah?
Thank you so much for a brilliant talk, Abby. And Ruben's to stick the first of my two questions, because that's something I've always sort of found bizarre, that particularly in the employment context, you'll have software promising to identify your most innovative employees and all that sort of rubbish. On a slightly related point is, to what extent does context specificity come in? Because another sort of measurement that we see a lot in the employment context is productivity, right? And so you get your weekly email or daily email from Microsoft Teams giving you your feedback on how productive you were today. And I can see that in certain professions that can actually, be a genuine measurement, right? If I'm in a call center and customer services, then maybe how many keystrokes I've done, how many calls I've taken is actually a measurement of my productivity. Whereas I guess for us academics, it might be the exact opposite, right? I mean, the moment I switch on my computer and do anything on MS Teams or email, my productivity drops to 0. And it's only when I've switched everything off that I'm being productive. So is there space for sort of context specificity as well in there?
Yeah, that's a great point. And also, I personally have thought a lot about these sort of organizational productivity measures as not meaning a lot in certain contexts. So also with you there. But I think where we think about context gets into sort of how we might evaluate it in terms of, sort of all of these evaluations are like, yeah, maybe this like measure of height doesn't matter in this kind of setting, but if I'm like deploying this in this kind of setting, does this matter? Does this still work? So sometimes this goes under the umbrella of like external validity, which for us falls partly in content validity for us. So yeah, I think sort of the fact that all of this ends up being about how like context matters and like who you're actually imagining using this and what the impacts are and if it applies is sort of, I think that's sort of the whole meat of it. So definitely.
Brilliant, thank you.
Max?
So yeah, very interesting talk. So I guess when I talk to people in CS, machine learning, in industry, I feel like you often get this attitude that, oh, the problem is just the data and we are fine, right? So like there's nothing wrong about the social impact of AI and the deployment of these technologies. I guess my counter reaction would be like, even if you perfectly measure what you want to measure, and even if you perfectly predict everything without error, I think there are still a lot of issues, in particular, I guess, related to inequality, for instance. If you take the productivity example, then the productivity as in your contribution to the profits of the firm. We even like by improving prediction measurement, we might actually increase inequalities. And so I guess I was wondering how you think of your work relative to this attitude of engineers.
Yeah, I mean, so it's relevant that, again, like my PhD is in computer science, a lot of this work came out of being at machine learning conferences and having these kinds of conversations where we are sort of trained to think that a lot of these pieces are really, like modular and can be like addressed separately and often have technical solutions. And there was a talk yesterday anyways, several of the talks yesterday really sort of bridged this well with thinking about where different types of, even if we are more precisely targeted, this can actually increase inequality. We get to sort of see these impacts throughout. So that's a bit of a ramble. So, I mean, I think because partly there is this like want to have technical solutions. There is a want to separate out the pure engineering of it. I think it's important to, again, sort of similarly to what I said before, like to sort of bring in like where assumptions are being made and how we think about sort of like the systems level consequences. Part of the work I didn't really have time to mention was where we're looking at other high risk kinds of settings where, you know, if you're trying to not have your naval submarine get into trouble, it's understood that it's not just a technical problem, but it's also like an organizational and cultural problem as well. And so settings where, you know, we can learn from, you know, how we understand sort of problems and systems, I think can be valuable also in terms of, in some ways, just sort of like normalizing that these aren't independent systems. So that's a non-answer, but
Right, let's take one last 10-minute break, and then we will conclude the conference with Mustafa's talk. So please, everybody stick around, and thanks, everyone.
Great, thanks.
Is that me or, because I couldn't hear you, Max?
Hello?
Yeah, can you hear now?
Hey, Mustafa, welcome to the conference. So very happy to have Mustafa giving our last talk today. And the floor is yours.
Thank you. Just trying to share my screen. Can you see my screen?
Unfortunately not.
Oops.
I
One
can
second.
see it.
You can see it?
Yes.
Yes.
Okay.
Yeah.
Yeah.
There you go.
Okay. Excellent. Yeah, so thank you very much for inviting me to speak at this conference. I got the invitation, and a few days ago, for some reasons, I had issues with my machine. And then I learned the hard way some of the logistic challenges you can have when you're working from home due to the pandemic. These challenges can unfortunately be more important, more damaging for certain, if you live in certain regions of the globe rather than in others, because I had a new laptop to be shipped to me, and it takes much longer to get here. Unfortunately, we found a way to have access to the system and to my document, and I'm happy to be able to do this presentation today. So what I would like to talk about is...
You're not sharing your screen anymore.
Do you have it? Oops.
Yeah.
You should see it now.
Yeah, better.
Excellent. So what I would like to talk about is how machine learning or artificial intelligence, if you prefer, as it is called today, is used to solve various challenges across the globe. And in particular, how where you are in your background can contribute to the set of challenges that you decide to solve. And ultimately, obviously, this has an impact on economic equality. So I hope in that regard, it is related to the main topic of this conference. So the challenges and the applications of machine learning I'm going to talk about have chiefly been tackled at Google, some of them by my colleagues in the Accra office, but others by other researchers and engineers sitting at other offices, whether it's at in Tel Aviv or oops. Seems we are having challenges with the shared screen.
You're back.
Okay. It seems like whenever you have your camera on, it disappears. So perhaps just sticking to the slides.
So I should just remove the camera. Is that
perhaps
right?
Looks like
okay.
That.
Okay, or I think I would just try to keep this tab active. Probably that's the reason. So as you know, now as other presenters have certainly mentioned, there has been tremendous progress in machine learning in the past years. I'd like to give this example where if you consider one of the most widely known application of machine learning, which is image recognition, and one of the most significant benchmarks for image recognition, which is ImageNet. In 2011, the best systems were achieving 26% error. And that accuracy went down to 3% error in 2016. Meanwhile, there has been some evaluations saying that humans on average make 5% error. So this is quite significant in a matter of 5 years. And these developments have sparked, and obviously they came initially because of the strong interest in the field, but they have also motivated a large number of researchers and engineers to enter the field and contribute. And as a result, for example, if you consider a platform like Archive, where we post most of machine learning papers today, in 2019, you had about 90 new machine learning papers every day, which is significant considering the numbers you could see around 2011 or 2013. In fact, this goes so fast that it even surpassed, in terms of speed, the Moore's law. So machine learning is being used today to solve all sorts of problems. And in 2008, the National Academy of Engineering published the Grand Challenges of the 21st Century. And you can see all these challenges in red, all those that are in red are actually being tackled with heavy use of machine learning, especially at Google, obviously in other organizations as well. The experts working on these challenges live in a very reduced set of locations in the globe. So this map is extracted from a study by a company called Element AI. They surveyed a few years ago where the machine learning experts are active. And by machine learning experts, they used LinkedIn profiles and stuff like that, and compiled those who were listed themselves as actively working in the field, publishing papers, working as engineers, etc. And as you can see, the bulk of researchers and engineers in this field are located in North America, in Europe, and in Asia, chiefly in China and Japan. The rest of the world is barely represented, and especially you can see this whole area, gray area in Africa, where you barely see some of these purple dots. A few years ago, we started a new research center in Accra, where I'm based normally. So this center is part of Google AI, which is a distributed AI organization with offices in North America, obviously in Europe, but also in Asia. So this one was the first in this region of the globe. So we're a team of engineers and scientists working to tackle some of the challenges that are interesting from a scientific perspective as far as machine learning is concerned, but also relevant to local populations. And I will be talking about some of these challenges next. So I live on a continent where all projections say that we'll be about 2.4 billion by 2050. Keeping in mind that we are about 1 billion people right now, and by far the youngest population on this planet, this doesn't come without challenges. Of course, it comes with many opportunities as well. But as researchers and engineers working in this field, where you are based, to a large extent, determines the kind of challenges that you decide to tackle, because research and development itself, I strongly believe, cannot be detached from the environment in which it is performed. So some of the researchers in our team, and more particularly the gentleman by the name of Ernest Mouebaze, who used to be with us recently and who is now faculty at Makerere University, with others, worked on using machine learning in agriculture. In particular, asked the question of how can we use modern techniques in AI in order to improve plants' health by using automated diagnosis. So if you look at this plant, for example, which is a cassava one, how can we just with a mobile phone diagnose this plant and take action before it is too late? It turns out that the same techniques used for doing semantic segmentation for various applications on the internet, deployed on the internet, can be used to solve this problem as well. And with modern techniques, such as quantization and compression, these models can even be deployed on smartphones, in fact, on even low-end mobile devices, which farmers can use when they are in their fields. So basically take a picture, and what the application brings is a segmentation like this, where it precisely indicates which parts of the plants are not healthy. And these can be used as an early warning system or as an initial diagnosis, so the farmers can take action while it is still time. So another important application that has received attention here is how do we use machine learning and modern techniques in computer vision as well in order to improve our understanding of populations. So this is important because many of the decisions in terms of policy making are based on measurements, on statistics that take time to compile, that sometimes are obsolete, but nevertheless, the decisions that are taken based on those numbers can have huge consequences on how various things are allocated, like capital, or where do we build, where do we increase water supply, where do we build new schools, etc. So as the world has more, the world's population increases, it becomes more and more important to have accurate statistics in order to guide decision making in terms of policy. So, for example, if you look at the buildings of the world, these buildings they look very different in different places of the planet, but nevertheless, they are captured differently by satellite imagery, which is the main source of for building maps, for example. So if you look at this this picture, you have buildings from various parts of Africa. If you look at the top left picture, this is a slum in Nigeria, which is actually built on the water. So if you look at these roofs, they have very different structures from the ones that you see on the right bottom of this image, which was taken in Kampala, for example. So how do we build models that are accurate enough to capture all of these variations, and then to allow us to understand where people live and how many people live in certain areas, how the cities grow, where refugee settlements are appearing, and things like that. So this is a very challenging task, which until very recently, most machine learning models could not solve. So if you look at the Google Maps, for example, in many areas, you may see something like this. And this is a direct consequence of the inaccuracies of our models. So in this map, you see very few buildings that are represented. So it's these squares and rectangles. It doesn't mean that in reality, there are no buildings here. It just means that the algorithm that takes the satellite image and then extracts the building from the satellite image in order to create these maps is not accurate enough. Now, if you have a service, let's say a ride-hailing service or another service that is based on information like this, you may end up having a different quality of service for people living here in Togo if you compare it to maps which are more accurate for people living in New York, for example. So for example, if you look at the same satellite image corresponding to this area, you can clearly see that there are many buildings here. They're just not captured by the algorithm. So what was done by a group of people in Accra and in collaboration with others in Zurich, and the whole team was led by John Quinn, who is a researcher in Google AI in Accra, was to design new algorithms, new models, and train those new machine learning models in order to improve their detection capabilities of these footprints, especially for when these buildings have shapes that are very different from most buildings that are in other parts of the world, right? Like in Europe or in North America, where these things are considered to be more regular and the streets are very regular. This is, by the way, also true for the roads. And this whole thing resulted in a significant improvement of Google Maps. So as you can see, the same map now with this new algorithm results in substantially larger number of detected buildings, and hopefully this will result in better services. So as you can see, if you don't experience the problem and the challenges, sometimes it's very difficult to understand to what extent these things can be the service, the quality of the service is different when you live in different locations. And we experience all of these things just because we live here, so we know how different the quality of maps is. So another project I wanted to talk about is about how machine learning is being used to advance health informatics. So this project is from researchers at Google with collaborators at other institutions in North America. And it's about diabetic retinopathy. So diabetic retinopathy is the fastest growing cause of blindness on the planet. And it's estimated that 415 million people are suffering from diabetes, and they are all at risk of diabetic retinopathy. And if you look at the projections, these numbers by 2040 will grow significantly in regions like Southeast Asia, Middle East and North Africa, and also Africa, doubling in certain cases. So this is quite concerning. But it's even more concerning is that even though this can be cured, it requires people to be diagnosed early. And there is a huge shortage of ophthalmologists. So how is diabetic retinopathy diagnosed? It's diagnosed by just looking at images like this, like these ones, where the ophthalmologists look at the retina and detect certain kinds of hemorrhages, right? To discriminate between healthy and diseased eyes. Now, you need ophthalmologists. You need trained ophthalmologists to do this. And in certain parts of the world, this is a very scarce resource. So what the researchers and engineers in this project did was to collect data, significant amount of data, and train deep learning algorithms in order to automate this diagnosis. And they eventually managed to get high accuracy models that can allow accurate early diagnosis of diabetic retinopathy. And hopefully this can help people to be treated before it is too late, because half of people who get diabetic retinopathy, actually, they become blind before they can even see an ophthalmologist. And these numbers were from a study in India. So another last application I wanted to talk about, which is also very relevant to many parts of the world, including Africa and Southeast Asia, is disaster prediction. So how can we use machine learning today if you live in areas that are prone to floods, for example, in order to very early on predict disasters and have people take the right measures before it is too late. So in the particular case of flood forecasting, so the team of AI researchers at Google sitting in Tel Aviv built an app that is actually now deployed at Google for people living in India, where they can get very early warning signals of floods. So this used machine learning with meteorological models and stuff like that. And this potentially can have a significant impact in terms of saving lives and similar things. So I think the main similarity between all of these applications is that it is developed and built by people who were aware of the problems. And they were aware of the problems because it is a relevant challenge and a pressing challenge in the areas where they are. And that's, in my opinion, a critical feature of transformative research in terms of making machine learning and artificial intelligence at the service of economic development, and in terms of and also to reduce inequalities and improve people's life. So this obviously doesn't happen without the expertise. So expertise, as we know it in this field, is not well distributed. So on our side here, we're trying to contribute to that area as well. So we created a few years ago the African Masters of Machine Intelligence. This year is our third cohort, where at the end of this year, we'll be graduating about 150 students in total who are now working in various companies in the public sector, in NGOs, and helping organizations, chiefly in Africa, use data science and machine learning techniques to solve their challenges. And those challenges include some of the ones that I mentioned in this talk, like the satellite imagery analysis project. So I'm just going to wrap up by saying that machine learning, I believe, can be a force for good. And I'm as a researcher in the field, I spend some of my time working on so-called fairness problems. So these are interesting problems because when these algorithms are deployed, they can be deployed in critical applications with potentially huge impact. But that's, I think, just one part of the problem. Another part of the problem, which we should also keep in mind, is what are the challenges and applications that we decide to solve with machine learning? Because deciding to solve certain kind of challenges only is also one way of discriminating and deciding what is important and what is not, and therefore serving certain populations and not others. So that's part of what we're trying to do here, and I'm glad to see that this is of interest to many people in this conference as well. Yeah, so obviously none of these things is easy, but seeing the enthusiasm and all the interest around the talks and the conference and in the community at large, I'm hopeful that that the future is exciting, at least in this area. So thank you very much, and I'm happy to take questions and discuss remarks.
Thank you very much for your talk. So I think we have already one question from the audience by Diego.
Yeah, can you guys hear me?
Yes.
Oh, perfect. Mustafa, thank you very much for that awesome talk. It's very nice to see the actual applications of all this stuff in real world issues. I work in agriculture, and agriculture is one of those areas that's generating a lot of data. but the issue is becoming of actually sharing that data and power relations, right, within the food sector and the food production systems. And I'm just curious, what is your guys' experience in Ghana with sharing and generation of data, and like what model are you guys following? And what I mean by that is like, do you guys generate the data and then everybody shares in the benefits of aggregated data, or like the aggregators buy that data, or what's going on there?
So this is an excellent question. So obviously, there's data is part of the challenge here. So I can speak about our own experience, at least from about the project, the crop disease diagnosis project, which was called CropNet. So the data coming from that project was actually collected by farmers themselves who were part. So I think for this to work, for this type of applications to work, it has to be built in a collaborative manner. I mean, obviously, this is true for any application. If you're going to solve something for people, you should involve them from the beginning. But this is especially true for these applications. So, so we worked with the Makerere, the AI lab at Makerere University, where actually the lead engineer in this project came from. And they had a set of people, group of people who worked with farmers to collect this data. I think, in general, for this type of application to flourish, we need better policies and quote unquote playbooks to collect massive data sets with all the safeguards in place, like the consent of those who provide the data, but also make sure that those who provide that data have the right infrastructure, because one of the challenges here is obviously the internet, right? So for people to collect the data and share it with us, they need airtime, they need internet connection, which is not always obvious, especially in rural areas. So you have to contribute into paying their the airtime or the internet connection. So you have all of these challenges, and it is clearly not a solved problem for us or for anybody working in this space. And I think a lot of reflection is needed, a lot of discussions and thinking is needed in order to come up with the correct protocols that can be replicated to collect this kind of data.
Thank you.
Yes. I guess I also have like a more high-level question again. So if I understand your talk, I guess you were talking a lot about how your background or your situation can affect what kind of problems you decide to solve, right? And that rings very true to me. And I think it can be true for various reasons. It could be true because of the kind of knowledge you have, or because of your material interests, I guess, or it could be because of the degree of empathy you have to different people in different situations. But I guess what I'm wondering is like how you think about to what extent that's also affected by the institutional constraints you face. And for instance, I mean, in some ways, no matter what kind of knowledge or empathy you have, if you're, say, in a certain profit maximizing company, then that's going to constrain what you can do and cannot do. And I was wondering if you have thoughts on that.
Yeah, absolutely. I think all of these things are, are ingredients that contribute to what you decide to solve, right? So the background you have in terms of knowledge, technical knowledge, contributes to how you will be solving the problem. Where you are and the rules that govern what you can do are constraints that dictate to a large extent the kind of problems that you can solve, and by the way, how you can solve them as well. Your immediate environment plays a critical role in the problems that you will select, that you will decide to solve, right? So if you're in North America, for example, where like the most widely used way for transportation is cars, then self-driving cars become important, and then you may elect to work on self-driving cars and using machine learning to build better self-driving cars which are safer, etc. And it becomes really, potentially an important challenge to solve, because it's important locally, I guess. I'm not from North America, so I don't know how important it is, but it apparently is. But if you are from this region, as I am, other things become suddenly more important. I mean, we have here pressing issues in health and in agriculture. We want to understand better the populations as well, to make better policy decisions, because the statistics agencies are not census is extremely expensive, as we all know. So it consumes resources. So, you elect to solve different problems as well. So there are various layers. I think that's the answer to the question, probably, at least my answer. And one layer is where you are. And that's why one of the things I spend most of my time on is to contribute to education, because to make sure that in the area where we are, that the talents are there as well, people who are trained to solve these challenges. Now, if they have the technical knowledge and they see these immediate challenges, obviously they may be constraints in what they can solve, depending on the working environment in which they are, right? So if you work in an organization that says you should open your eyes on this and close your eyes on that, then obviously there are certain problems that you will not be able to solve. It depends on what you do, but that becomes very personal decisions, right? So if you're in a place where you cannot solve the kind of challenges that you want to solve, and that is actually very important to you, you should just go to a place where you can solve them. If that is possible. I mean, those decisions are complex. They are taken at a personal level, but that's my opinion about this. As far as I'm concerned, I'm happy to be able to work on some of the challenges I mentioned in the talk. Yeah.
Thank you. Who's next? Everybody's tired after 10 talks. Right. I'll try in a minute. But for now, let me say this was the last talk for our conference. I found it extremely interesting and instructive, and a lot to think about and to be confused about. We are also going to post the recordings of all the talks on the YouTube channel for all of you who agreed. And I've already uploaded for most of you the papers and slides where you sent them to me. And yeah, I hope we stay in touch and continue these conversations. And thanks to all the panelists for participating.
And I think a big thank you in return from all of us to both Binte and you, Max, for bringing us together and curating such an amazing 2 afternoons of discussion.
Plus one. Thank you very much on that. Yeah, for inviting us.
Oh, yeah, absolutely. Also, thank you to Binte. Everything went extremely smoothly, which is not usual.
Thank you for having us. Yeah. Yes, thanks so much.
All right. Have a good afternoon, evening, depending on where you are, and see you all around. Bye.